Hello, welcome. Now I invite Professor Rahul Mishra on stage.
Okay, good afternoon all. Now we have a lecture on how to copyright your software in India. The lecture is presented by Tarun Jain. Mr. Tarun Jain is practicing as a company secretary and founder of Tarun Jain and Associate, having immense experience since year 2001. He has been sharing his knowledge and providing quality professional services from over more than a decade now. He has been providing best possible solution to almost all kind of business problem in the field of corporate law, foreign exchange law, intellectual property rights, taxation law, and insolvency bankruptcy laws. He also listed as a qualified valuers for valuation of financial and security assets. He is a law graduate, company secretary, insolvency professional, trademark agent, and a business valuer. Now over to you, Tarun.
Yes, sir. Thank you so much, Manishji, and all dignitaries for giving me an opportunity to share my thoughts on the copyright of software in India. Before I proceed to explain my thoughts about the software of software registration under the copyright, I would like to share that what is the copyright. First, we have to understand what is the copyright. Copyright is the right which is being given by the just a second, sir. Copyright is a form of intellectual property protection granted under Indian law to the creators of original works of authorship. It is actually the copyright creates automatically. Sometimes we are filing this copyright for getting the protection under the act, so that we can take infringement actions. But now actually the copyright creates it automatically. When any person creates any work like literary work, dramatic work, musical work, artistic work, cinematographic films, and sound recordings. So whenever the work is being created, copyright is already created itself at the time of creation of the work. But in respect to the software, when the work is being saved in any CD or any pen drive or any medium, then it is being created from the date when it is generated into that pen drive or the CD or the another media. In India, the intellectual property rights of computer software is covered under the Copyright Act. Accordingly, the copyright of the computer software is protected under the provision of Indian Copyright Act 1957. Computer programs are literary works under the definition in the Copyright Act. A computer program is a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. Copyright for computer programs prohibits copy of program structure and design by any other person, means that by any another unauthorized person. You can give an authority to any other person to use or copy your software or any your literary work. But if other person is using this without any permission, then it is called infringement. That I will explain you later on. The graphic sounds and appearance of a computer program also may be protected as an audio-visual work. Protection of copyright software. How it is being protected? Copyright protects the form of expression of an idea. Basically, what is the copyright protection? Copyright protection is related to the form of expression of an idea, not an idea itself. If you say that I do have an idea, but that can be protected under the copyright, patent, or etc. anywhere. So idea itself is not protected; it cannot be registered. So it is a form of expression which is being registered under the copyright. Form of expression means that when we are talking about the software, it typically means that the computer program in both human readable, that is source code, and machine executable form, that is object code, and the related manuals are eligible for copyright protection. What is the source code? When you are going for registration of the software, then authority is asking about the source code to provide the source code. This is manually readable form. But object code. But when we are saving software in CD or in any DVD or any kind of hardware, then it is called as object code. So they are asking both the things. One is the source code and another is the object code. They are asking both the things for getting it registered. So this is a form of expression of an idea. This is not only an idea that you are expressing some hardware. Software is being embedded in hardware that is being registered. So copyright subsists in all original published or unpublished literary work. That I already explained that unpublished work is when you are creating any copyright, when you are writing any book, when you are creating any software, literary work, musical work, cinematography work, even if it is not being filed for registration, it immediately creates the copyright. So that's why it is published or unpublished literary work. So literary work includes computer programs, tables, compilations, including computer databases in any technical form. Therefore, work has to be recorded into program on some tangible medium to get copyright protection. Copyright protection is automatic form, as I already explained that it is an automatic form the moment the work is embodied in some medium like ROM, magnetic tape, diskette, etc. Registration procedures for filing copyright. Copyright registration software, copyright, and an application for copyright registration contains three essential things. Number one, that the application has to be filed. Number two, the fees has to be paid. And number three, the work, the CD, or the diskette, whatever you have embodied in, has to provide it. It is not refundable. A copyright registration is effective on the date when you are filing an application and you are claiming that you remark that the work is published or unpublished. Regardless of how long it takes to process the application and mail the certificate and the registry is issuing the certificate. It depends upon the nature of the work, how long it will take. Sometimes it takes 6 months, sometimes it may take 2 years. It depends upon all what kind of the nature of work and the objection is raised by the department. So there are two procedures of getting the software registered. One is the online registration, and another is the hard copy that you can submit the copyright office. When we are filing a copyright application, there are certain forms and requirements. A statement of particulars is we have to file. A statement of further particulars we have to file. Name and address, we need the name and address of the applicant. 3 copies of the work that you are filing for, or along with the CD of the software. Otherwise, online filing is also possible. Then we can also file online application for software. NOC from the software developer. As you know that the software can be developed by the main body only. So sometimes it happens the company filing an application for software registration, but in that case, NOC from the software developer is mandatory to be attached there, so that no objection should be there from the software developer. In that case, the company can file an application for software registration. Along with this, the power of attorney, the approval of the attorney is also required. Now we are talking about the registration. We have talked about the registration of the software, how it is being done. But now when software is registered or not registered, there is a piracy of the software. As we all are aware that there is that the people are doing the copy. So there are 4 kind of things wherein the infringement of copyright is done. Number one, end user piracy. What is that? End user piracy means the person in an organization or in home, and the people are using software which is being registered in the name of any other person like Microsoft. the people can use in home or in organization without getting a license, proper license. If their supplier is providing services of installing unauthorized software in their system, then they are liable under the infringement of copyright. The Microsoft or any organization whose software that person is using without taking a proper license will be liable under this and user piracy. Hard disk loading. Sometimes it happens that people are going to purchase some computer, laptop, etc. And the supplier himself provides some software on the basis of one license they have purchased. On the basis of one license they have purchased, they are installing unauthorized manner, in unauthorized manner, that software in the laptops or the computers the people are purchasing from them. This is also a piracy of the software. Though it is also not allowed an amount in infringement, and the person who is using and the person who is supplying this kind of software, both will be liable under the Copyright Act for infringement of their rights. So software counterfeiting, the illegal duplication and sale of software, the person who is supplying this software and installing in another system will be liable, as I explained. Hard disk loading, software this is called software counterfeiting. Internal piracy, sometimes it happens the person is purchasing in an organization. Sometimes it happens that the person is purchasing one software and using 50 computers. And that person thinks that he has purchased the proper license and is installing that license into another 50 computers that he is using, and think that he is a genuine person and purchased license and using it in a proper way. But it is an infringement. He is not authorized to copy, reproduce or use this software in multiple computers. He is authorized to use it only in single computer. So this is also called as a piracy. So until and unless the owner or the author give permission, this is called infringement. Remedies, these are the remedies which are available against the infringement of the copyright. The person who is suffered with can file suit for temporary and permanent injunction, impounding and destruction of all infringing copies, what he found at the premises of the infringer, including the masters. Actual monetary damages plus the infringer's profits. This is also a big blow to the person who is infringing the things. So that can also be claimed. Court cost, the attorney who is being appointed can also be claimed under this infringement suit. Any questions in this regard? The copyright software till now? Hello? Should I continue or if there is any questions?
No question, sir.
Okay.
You're good to move ahead.
Yeah. Thank you. Now I am proceeding for the patent. Patenting or this is not patent for the original layout design. Now semiconductor integrated circuit layout design. Before proceeding with this technology under which the semiconductor integrated circuits are being registered, I would like to discuss some concept of the patent. There is a copyright, patent, trademark, and SIC LD Act and the design patenting, under which the people are getting confused where they should move into. So semiconductor integrated circuit layout design is one thing on which I am supposed to speak and share my views. Before going into this, I would like to share the basic concept on which people are getting confused whether it is patentable or whether it is not patentable. Under the patent, before this, I would like to share what is patent. Patent is basically related to the innovation and novel things, original things. Innovation must be there, the novelty must be there, and the original creation, which is not available already across the world, not only in India. If you are proceeding to file a patent application in India, then the search has to be conducted across the globe to find out if the thing that you are supposed to file in a patent department in India is available or not available across the globe. People sometimes get confused that we are filing only in India, so we should conduct the search only in India. Whereas the patent is to be searched across the globe, even if you are getting it registered in India only. So it is the right which is the government giving for exclusive right to make, use and sell an invention for a specified number of years. The maximum number of years in patent is 20 years. Qualification for an invention to be patentable. This is a novel, non-obvious industrial applicability and inventive steps should be there. So the question normally arises, why not patent for the original layout design? In India, original layout design of the semiconductor integrated circuit is not patentable. It comes under there is a special act created by the government in 2000 that is called the Semiconductor Integrated Circuit Layout Design Act 2000 and Semiconductor Integrated Circuit Layout Design Rules 2001, under which the person is authorized to file layout design. There is no other way out to get it protected. It is not patentable because under the Patent Act it is specifically mentioned that topography of integrated circuit is not patentable. This is specifically the layout design. Topography means that the layout design of the semiconductor integrated circuit. So it is not patentable. Only the technique how you are created a semiconductor or the integrated circuit is patentable. Like Intel is filing lots of applications across the globe about the integrated circuits. So in India, it is layout design is protected only in the copyright, not in the patent. So despite the creation of the mind are not patentable because they do not possess an inventive step, which is one of the important requirements to get a patent. The layout of this is the office of registry is yes, one important thing is that SICLDR is situated at Indian Patent Office and applications are being filed there only. And until now, only the Bharat Electric Limited has filed few applications, as it is not being what I feel that it has not yet been promoted significantly. So that's why the people are not filing lots of applications under this act. So now the point is that what is semiconductor integrated circuit? Semiconductor integrated circuit, as per section as specified in SICLD Act, semiconductor integrated circuit means a product having transistor as well as the circuitry elements which are inseparably formed on a semiconductor material or an insulating material or inside the semiconductor material and designed to perform an electronic circuitry function. This is a very important point that there are few elements which are to be connected with each other and designed for the purposes of perform an electronic circulatory function. What is layout design? This is semiconductor integrated circuit, and what is the layout design? Layout design is the means a layout of transistors and other circuitry elements and includes lead wires connecting such elements and expressed in any manner in a semiconductor integrated circuit. This is the layout design. what are the criteria for the registration of the layout design of integrated circuit? The question was arise about this. So what are the criteria? So it should be original. First thing that work should be original, but not innovative. The difference between the patent and this act is that about for registration under this act is not required the novelty. That's why it is not patentable. If it had a novelty, then it could have been registered as a patent. But it is not this, which is not. The thing is that it should be original. One thing that it should be distinctive, and it should be distinguishable from any other registered layout, and it should not be exposed to outside world. It should not be exploited anywhere. It should not be exposed anywhere. The period of 2 years, if it is not exploited or exposed for a period of 2 years before filing, I mean that 2 years is exempted before you file an application for registration of semiconductor integrated circuit layout design. 2 years is are exempted. That if it is exposed for a period of 2 years before filing an application, then it is exempted. It is allowed. But more than 2 years, it is not allowed. So these 4 points have to be taken care of while we are filing an application for semiconductor integrated circuit registration. Now the procedure for registration of semiconductor. What is the procedure is that? First we have to file an application of the layout design registration. Registrar may accept, refuse or modify before accepting the application. Once it is accepted, then advertise within 14 days of acceptance. 3 months period is there for the public opposition. If anyone want to file an opposition, want to create any objection about this registration, then that person can file within the period of 3 months to the registrar that we do have an objection, and within 2 months from the date on which the registrar intimate to the applicant, the 2 months will begin for filing a concurrent statement. A copy of the concurrent statement is also required to be sent to the opponent who has filed an opposition. The registrar may take after once the hearing process, once this evidence process will be completed, then registrar may take hearing with the parties and decide on the originality of the layout design. Aggrieved party can appeal to appellate board or in its absence to the civil court for relief on any ruling of the registrar. The registration may be valid for a period of 10 years. And legal protection for the duration of 10 years is said to be sufficient in the fast changing world of IC technologies, which is being changing rapidly. Violation of layout design. The penalty for violation, what is the penalty of violation of the, if anybody is copy the layout design, then there is a penalty of 50,000 rupees and 3 years jail, and 50,000 can reach up to an amount of 10 lakh rupees. And both can be imposed if it is of a severe kind of. There is an initiative by the government, unlike the software production and service industry. Semiconductors has not been a visible core strength of the country so far. However, for the last few years, the Indian government has been working on changing this. Upping the Make in India and Atmanirbhar Bharat campaigns, the government has introduced few schemes, which is including the design incentive. In this December last year, the government approved the Semiconductor India program, Semicon, with an outlay of 76,000 crore to develop India's semiconductor, which is a very welcome, very big welcome step of the semiconductor design and manufacturing ecosystem, whereby all this will be done. Any questions in this regard about the semiconductor, please?
Any questions? Okay. No, sir, we are good to move ahead.
Okay, so my submission was that the software registration of the software and the semiconductor integrated layout design I have explained the things. So my submission is over. If there is any query, then we can discuss. Else, I'm completed with my submissions.
Yeah, sir, we have one question. I'll request the questionee to come on stage and ask.
Okay. Or otherwise, you can share the questions with me over my email ID.
So you mentioned about the novelty and distinctive case, that is the difference for the filing that patent and copyrights. So my question is that in case of semiconductors, how do you define this and novelty, and or because I think that originality and distinctiveness is also a kind of definition for novelty. So how, if you can give an example in case of semiconductor layout, what are the different categories in which one is can be mentioned in patent and one can be mentioned in this novelty case?
Oh, in India, layout design is prohibited to file under the patent. Only the layout design. It is not prohibited if you are establishing some semiconductor in a technical, the process is not prohibited. Only the layout design is prohibited to file under the patent. Like if you are filing as a board PCB, the PCB kind of thing or the semiconductor layout design, that you are filing under the SICLD Act, but not under the patent. In patent, you have to establish the novelty that nobody knows about. Like for example, if you are saying that CFL is providing the light and the yellow bulb is also providing the light. So both the bulbs are not an invention. Invention, bulbs are not, the product is not an invention. People are aware about that something is there, that light is coming from the bulb. It is not an invention. Only the way you have changed. But now technology that you are creating is patentable. Like it is in semiconductor registration, that the product that you are filing, the people are aware about that this is a semiconductor integrated system and layout design. So it is not patentable. It is comes under this act only,
Okay, sir.
like Design Act. But it is a different from the Design Act. That's why the government has created this in 2000. This is a separate act, special act.
Okay, sir. Thank you, sir.
Yes.
Do we have any other questions? Yeah, sir, we are done with questions.
Okay. Should I close now, please?
Yes, sir. Thank you, sir.
Okay. Thank you so much. Thank you.
Thank you for joining us today online.
Thank you so much. Thank you. Bye.
Thank you for joining, sir. Now I request everyone to. We are taking a lunch break for an hour. I request you all to join us at cafeteria. Lunch would be provided there. We're taking a break for an hour, so we will meet at 2:10. Okay, we'll meet at 2. Thank you. नहीं
हाँ
सिर्फ
मीटिंग
आप।
ऑन रखनी है।
और सर वो मैंने सेशन रिकॉर्ड कर दिया, वो रिकॉर्डिंग्स में है,
सर
ठीक
आपके वेबएक्स में मेल में आ जाएगा।
ये इसको अभी रहने देना ऐसे ही।
और सर मैं वो भी चेक कर लेता हूँ, और जो मीटिंग है ना उसमें भी रिकॉर्डिंग रहेगा, वो मीडिया पर चैनल है ना, तो उसमें भी
अभी इससे लॉग आउट मत करना।
नहीं नहीं फिर मेरे
ज्वाइन
पास
अगर कोई ज्वाइन करे ना तो इसको
ओके सर,
वेलकम कर लेना, ठीक है ना।
ऑडियो वीडियो चेक कर लेंगे।
हाँ, और वो जो इको आ रहा था वो भी चेक कर लो।
मीटिंग चालू ओके। अब मीटिंग में ये बोलूँ का तो તમે એને એક કામ કરો, હું લિંક ઓપન કરું, હું બહાર જઉં તમે ખાલી બોલો
हेलो हेलो हेलो
એવું છે એમ ઉભા રહો જોઈ લઈએ, મેં અત્યારે મ્યુટ કર્યું છે, હવે હું પહેલાં ખાલી મીટિંગનો ચાલુ કરીને જોઈ લઉં એટલે તમને અવાજ સંભળાય છે ઓનલાઈન, તમે વાપરો યુટ્યુબમાં. હલો ના એના પછી તો અમે હું પ્રિયાંકભાઈ છીએ. એની આઈ થિંક યુ મ્યુટ કરે.
Okay. So we begin 15 minutes late. Fortunately, this slot is 1.5 hours. Usually, I'll use this for 1 hour of lecture and half an hour of quiz or any other interaction. But today, I'm going to use the entire 1 hour and 15 minutes.
બંધ જ સેટિંગ કરે નહીં હા આપણો અવાજ નહીં
અહીંથી જ નહીં અને લાઈવ વાળું
લાઈવ તો લાઈવ કહે છે પણ આપણે વાત
એમ નહીં પણ સામેવાળું કોઈ બોલતો હોય બેસવાળું અહીંથી કોઈ ક્વેશ્ચન આન્સર કરતો હોય ના જાય અત્યારે ક્વેશ્ચન આન્સર કર્યા હા એટલે એ તો ચાલુ જ રાખવું પડશે ને એનું થોડું ઓછું કરવું ને ઓડિયો
हाँ वो कहाँ गया? अच्छा ही इज ऑनलाइन। ठीक है ऑनलाइन है ना, ठीक है। अच्छा इनकी पीपीटी यहाँ डाली डाले इन केस उन्होंने मेरे को मेल किया। इसको भेज मैं इनकी पीपीटी भी यहाँ पे अपलोड कर दूँगा। अच्छा ये पीपीटी है उनकी, उनकी पीपीटी है ठीक है। उन्होंने मेरे को भेजी थी इनकेस इशू तो मैं क्या करूँ किसको भेजूँ? अपना ईमेल एड्रेस टाइप करो ना, तो यहाँ से निकाल लेना इनकेस कुछ अटक जाए ना अभी इसलिए अदरवाइज एड्रेस से ही भेज दो। हाँ नहीं मैं ऐसे नहीं करूँगा। ये उनका पीपीटी क्या है मैंने पूछा। हाँ वही ना, बात हो गई नहीं सर मैंने इसे कर दिया एडमिट पर वो आ गया हम यहाँ पर उस टाइम रिक्रूटर मैंने तो कर वो अनम्यूट कर लो। ठीक है
Hello. Hello. Hello, Andrew. Are you there? Hello.
Yeah, can you hear me?
Yes, we can hear you.
Oh, good morning or good afternoon there.
Oh, wait for a while. Let me introduce you to the audience, then you can proceed.
Oh, we're starting? Okay. Let me share my screen also.
Okay, definitely. Very warm welcome to Andrew Michael ONG from WIPU. And words are less to explain the achievement by him, but I have to say something. Andrew Michael ONG is highly skilled professional working in the field of intellectual property and international law. He is currently serving as Director, Division of Asia and the Pacific World Intellectual Property Organization, WIPO, which is a specialized agency of United Nations responsible for promoting the protection of IP worldwide. With over a decade of experience in IP field, Mr. Ong had developed a wealth of expertise in areas such as patent law, trademark law, and copyright law. He has gained extensive experience in international IP policy, having worked on various projects and initiatives aimed at improving the global IP landscape. He holds a law degree from prestigious university and have received numerous awards and honors for his outstanding contribution to the field of IP. Mr. Ong is also professor of Philippines Judicial Academy of a Supreme Court of Philippines and taught in the College of Law of University of San Carlos. He co-authored the book on the trademark entitled Protecting Marks of Ownership. He is practicing lawyer with LLB from University of Philippines. He ranked number 6 in Philippines bar examination in 1993 and proceeded to specialize in intellectual property law, alternative dispute resolution ADR through continuous legal training, practice, and consulting work before joining public sector in 2009. So over to you, Andrew.
Thank you, Thank you, Professor Manish. I don't know if you can hear me.
Yeah, we can hear you.
Okay, wonderful. Thank you for that very kind introduction. I was amazed how you were able to dig up my ancient history. It's been a while since all that had happened, and I'm very happy to be here today. Thank you for this opportunity. I met you through LinkedIn, and with this, we have this first engagement with your audience, with the institute, and with your stakeholders. So it's my pleasure to be here. And I hope this is also the time when we can also connect with everybody else. So that's the purpose really of why I'm here, is to be able to help connect the dots and to be able to add value to the discussion. I do understand that the discussion today is very technical. And probably I am the odd element that's more general and generic compared to the technical discussions today. But nevertheless, I hope this can open other doors as well for everyone. So my segment will be on simply a very superficial introductory to the WIPO services or WIPO services and tools. So that hopefully we add value to the discussion with an international experience or opportunity for IP and IP professionals and IP users and IP beneficiaries. So just to move on, let me try to see if I could move my slides. Okay. Okay, there. Okay. So just a quick introduction. So the WIPO is the UN agency. We're one of the 17 specialized agencies. We're based in Geneva. And of course, since time immemorial, our mandate has always been to help the world create an inclusive and a balanced global IP system that serves the interests of our member states, who are our stakeholders, right? And we have 193 member states at this point in time, which is equivalent to the United Nations membership as well. And we serve in the institutional level, the community level, and now we are venturing into the individual level. So which brings us to interesting areas and interesting opportunities. We're 1,600 staff strong. We come from 121 countries, and a big portion, 54%, are female. So we're happy with our gender parity, although we want to improve more, especially in our top management and our managerial positions. As I said, I'm based in Geneva, but I'm ASEAN. I'm from Southeast Asia. I'm Filipino, and we have external offices that are based nearer to the countries in Asia. So we have 8 external offices. In Asia, we have in China, we have in Japan, and we have in Singapore. And the one in Singapore serves India, as well as the other South Asian countries, as well as Southeast Asia. I belong to the Asia Pacific Division, which is the what I would fondly call the cost center of the WIPO, because we are in charge of helping countries and helping institutions and now individuals to know more about the WIPO services and how to embark on a joint collaboration or joint endeavors that will benefit and bring IP closer to the ground. And on the other hand, also, we hopefully will be a gateway for you to enter WIPO, to know WIPO, and to be featured by WIPO. We do feature a lot of interesting, inspiring stories about IP journeys and people touched by IP. So let me go to my next slide. So that's where I'm coming from, and that's where I am. For further information, you can look at our WIPO report 2021, and I placed the link in the slides. I've also given Professor Manish a copy of the slides so that everyone can also look at it after. So in 2020, we had a big milestone. We had a Southeast Asian appointed by the member states as our Director General. So Darren Tang is a Singaporean, has been the former head of the IP office of Singapore. So with that, there's a new impetus right now to bring IP to the global south. And I know along that line, India is one of the leading countries and champions. So we're happy to be able to work with India more and more. In fact, our Director General will be visiting India pretty soon. And also, it's a very big possibility that we will have more and more WIPO staff flying to India and having some collaborative activities. So the mantra now we have in the organization is IP for everyone, everywhere. In fact, we just launched our IP for everyone, everywhere website 2 days ago. So this is our new mission and vision. It's our medium-term plan as well, to be able to bring IP to more people, to a wider stakeholder base. And under this big mandate, we have 4 areas. I guess you can capture it in these 4 areas. We have an outreach pillar, which is the leftmost pillar. That's where I belong to. So we would like to reach out to be able to communicate, to be able to have an interaction and engagement with stakeholders at even the close level. We have also our forum functions. We are the vehicle place where international discussions are taking place, and I will share that a bit in succeeding slides. We also have our the profit center, if I will call it, where we have our PCT, our patent treaties. We have our trademark treaties as well as our design and geographic identification treaties, where we operate these treaties, and these are filing mechanisms, registration mechanisms to help globalize, to help transactions and transfers between and among IP systems in the world. And lastly, we have our policy support, which is our a big chunk of our development work in the past, where we help governments, institutions in establishing IP in terms of legislation, in terms of policy, and in terms of institutional support. So these are the 4 pillars, and these all of our services and all our tools stem from any of these 4. So with our new website, I just want to introduce you because this is a good way to land to WIPO information and live WIPO library. So in the website, we've divided it into where you are. So if you're on the upper leftmost, you're new to IP and wish to know more, you can log into our Understand and Learn page. If you are a bit more aware already with IP and probably are using IP, you'll find interesting things in our Find and Explore, where you will find our databases, laws of different countries, some statistics, and other reports. And if you are in the business of IP, you have an application, you have a commercialization journey on IP, or you have a transaction that's happening involving IP, whether within across borders, within the region or across regions, this will be an interesting place for you. And if you wish to partner as an institution, then we have the fourth page, partnering and collaborate. Of course, the last page is a general information of WIPO and our services as well. So just want to stress that in the first page, the understand and learn page, we do have a subsection where we expand IP and relate IP to the other public policy spaces. So we have IP with genetic resources, IP and genetic resources, traditional knowledge, traditional cultural expressions, and we have an upcoming diplomatic conference in 2024. That's early 2024, next year, and that will be interesting for India to look at, and as well as for the institution to look at. We have IP and economics, which is run by our Chief Economics Division. And these are where the Global Innovation Index is coming from, which is, I think extremely important. We've seen India rise through many rounds, and not just through the years consistently, and it's exciting to see where things are moving by other countries as well. We have gender, IP and gender equality, which is the big theme for this year's World IP Day. So there are lots of materials here. We have IP and global health, IP and climate change, which is extremely important now, and IP and competition policy, and who knows, this is an important and growing area, because a lot of the investments on technology these days cannot be done by one or two companies or one or two researchers. It's normally a collaborative open innovation approach. And for that reason, there will always be situations where several big companies invest and introduce a technology that they jointly own. And so the monopoly, the limited monopoly that IP affords, has some competition issues. So here we have discussion on that. Also SDG as well as IP enforcement. We also have the IP in pages, where we can look at IP on a more deeper, narrower element. For example, IP in frontier technologies, which I understand ICC folks will be very interested in, and I'll show another page on that, IP in mobile applications, sports, and tourism. So on the IP and frontier technologies, we can dig into the AI page we have, and our IP and data pages as well. And one thing also that I must stress is, aside from getting whatever report or information or conversations that we have across countries, which is actually our value add discussion, the international element of things, we are also going to benefit, and countries are going to benefit from your contributions to the conversations. So we hope this will be a two-way street. By looking into it, you find things interesting for you, and feel free to approach us, reach out to us, tell us you have things that will be interesting for others as well, and we'll be all ears on that matter. So we also have the frontier technology for IP offices, which we are working with different offices to introduce, for example, the blockchain technology to understand its impact on the examination and registration. Okay, so going to the second page that we have, which is Find and Explore. If you're already familiar with IP and to know more about and use and tinker with and increase your experience of IP, we have the Patent Scope website, which is a free patent searching database. And we have the user guide as well as an e-tutorial to help you go through that. We have the patent analytics team in WIPO that does patent landscape reports on various technologies. This will be interesting both from what you can get from WIPO, at the same time also from what you can contribute. If you have patent landscape reports that you're doing, it will be great to have that discussion on how we can disseminate it jointly. So there are other pages here that will be interesting for you probably. The trademark page, the global brand database, which you can search if there are similar brands or trademarks in different classes in different countries, as well as designs and geographic applications. So this is our second page in the website. And here also just want to point out that we have the patent registry portal, which in case that you need to know the legal status of certain applications or certain patent technologies, this can be your page. Let me see if I can share a bit and move to another page in my screen, just to give you an example of the tutorial. Here we go.
When searching the validity of a patent, you look for information that is scattered in different registers and authorities. To guide you to the relevant source of legal status information, we have developed the Patent Register Portal, an interactive directory. Let me show you some of its features. The default map view displays tabs showing which information you can retrieve in a register and what kind of search it allows. See, for example, which countries have an online register or provide an English interface. You can navigate the map or search country names. Each country has a fact sheet with links and a detailed jurisdiction file you can download. Use the detailed jurisdiction file section to quickly access any of them. In countries where there is no online register, here in Kenya, for example, we provide contact details to the relevant national authority. You may also want to explore regional organizations or patent information collections. Use the membership map for that. If you look for registers that fulfill multiple criteria, use the map view with filters. For example, let's see in which countries there is an online register with an English interface, allowing search by applicant name, and providing information about fee payment. Activate the search. You can see that in Latin America, Colombia matches these criteria. The Patent Register Portal has global coverage and is free. Find it on WIPO's website.
Okay, so that gives you an idea of what patent register is, but it also shows you the international experience that one can get in terms of IP. And when we talk about technology, when we talk about novelty or inventive steps, we always look at it from the international, the global perspective. So this is where actually WIPO is contributing to the discussion, to the service, and to your needs. Okay, so let's move on to the next page. Also, when you have an application already and you have certain instructions on IP, probably some of these pages will be interesting for you. Of course, the EPCT, where a lot of payment transactions discussions are happening. We have also the e-metrics for trademarks, as well as e-hay for designs. So this is the page for you. So just to summarize, we can look into patent scope, which is 4 trillion patent documents. The Patent Register Portal, which we just discussed. We can look at the patent landscape report that could give you state-of-the-art information. That's the technology industry area we're looking into. And so there are many other things here. This is for brands, so the brand global brand database, the Madrid monitor, if you have a trademark applications across different jurisdictions and things like that. Okay, so that's pretty much our services. Now, considering it's a university, it's an institute of learning, the academy might be of interest to you, both in the area of learning in our schools, in their different training programs, as well as our distance learning courses. So here we have in our academy a catalog where you can update. If I'm not mistaken, we have quite a big number. In fact, the biggest is in Asia, or in second biggest in Asia, where we have Indian students joining us. One area will be probably very interesting also for you is the area of patent search or patent information. To be able to understand and know whether one's endeavors have a similar or a related endeavor being done in other countries or in other institutions or in other universities. So we have the distance learning course on how to do that, patent searching. So this is a distance learning course probably interesting for many. And let me see, I'm going to my last slide. This is a WIPO service where we link with institutions, chambers, but most likely is universities. Where we have a proposal to have a continuous engagement by creating what we call Technology Innovation Support Center, which is linked to other centers in the country and linked to WIPO as well as WIPO's other support centers globally. There are about 80 countries now, and more than 1,000, more exact, 1,100 desks now all over the world in different and varied development stages. Some are very advanced. They do patent search, patent landscaping. Others even do commercialization, technology transfer, negotiations, and related work. Well, there are those that are still starting. So this is an area where we accommodate at different levels of development, universities and interests. So the technology innovation support centers is a service of WIPO that could bring an international element into the institution. So lastly, I just want to say that this morning I woke up looking at our LinkedIn page, and so I'd like to use this opportunity to invite everyone if you can sign up for a community. So I know there are issues, so there are some questions that you have at some point in time, and this is how I met Professor Manish as well. You can post, you can share information, you can ask questions, or you can send us private messages. So we'll endeavor our best to be able to serve you. So just this morning when I woke up, I saw in the LinkedIn page our chief economist was looking at the different correlations, and then we see the correlation here of patent filings and more specifically resident patent filings, and this is a very important element that here we know how much is the accessibility of the IP system or patent system to local inventors or researchers. And we see there India in a very good place, high above the GDP per capita line. And so there we could see many countries, surprisingly, we see countries rather developed and in lower below the line, and so we are very encouraged by the fact that India is way up on that stage. So now I guess the challenge is how to bring it to the level of the community, the level of the institutions. How much of that is related to or is contributed by the institutions. So on that note, on that very positive note, let me end my sharing this morning. And if you have questions, I will endeavor to answer. So thank you so much, Professor Valis. Thank you very much, and back to you.
Any questions? Okay, thank you, Andrew, for your such nice suggestions. And we shall provide your slides to the participants so that they can go through and connect to you. Thank you for such a nice talk.
Thank you so much. Bye. Bon weekend.
Okay, bye-bye.
Thank you, sir. Thank you, everyone. Now we are taking a short tea break for 15 minutes. Okay. 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 So, moving ahead, we have an hands-on session now. We have to proceed with that. I invite Tapas, Professor Tapas on stage.
Okay. Okay.
Good afternoon, everyone, and welcome to a hands-on session. So, it is my immense pleasure to introduce Ms. Kavita Saha, who is an independent patent agent and consultant. So, Ms. Kavita Saha did her MSc and PhD in microbiology in 1998 from Gujarat University. She passed patent agent examination in 2010 and is a registered patent agent with Indian Patent Office. After attending a training program on patenting in the field of generating engineering and technology held by National Institute for Intellectual Properties Management, she worked at H.K. Acharya and Company as a scientific officer in the patent department. She is currently working as an independent patent agent from a decade now and have done prior art search as well as the drafted and filed patent application for clients, both individual and companies. She has conducted search, drafting, and patent application for different fields of invention, which include mechanical engineering, computer engineering, food processing, and fabric weaving, Ayurveda, mathematics, microbiology, etc. So today's her presentation is on, or hands-on is on the patent searching, and her second hands-on is on patent proposal writing. So welcome, Ms. Kavita Saha.
नहीं सर मैं अपने में
So, hello everyone. Can you hear me? I am Kavita Shah. I am a patent agent, and a brief about what is patents. We come to slowly to patent search, and then we'll do hands-on training, right? Patent. What is patent? You must be knowing it is an exclusive right granted by the government to the applicant for his new product disclosure of the new product process, which is new, non-obvious, and industrially applicable according to the patents law. As the inventor gives discloses his whole invention, the product or process, he is given a legal protection of 20 years, in which only he can manufacture, sell, manufacture, buy, sell, use it, anything. Only he can do it, or anyone with his permission can do. Otherwise, no one can use it. What is a patent? It is an exclusive right granted by the government to the applicant or his assignee for his disclosed invention of industrial product or process, which should be three criteria there: new, novel, non-obvious, and patentable And industrially applicable is there. The fourth one is under Section 3. It should not fall under Section 3 of the Patents Act. Invention. What is an invention? It should be new. It should have an inventive step, and it should be industrially applicable. And it should not. It must consist of patentable subject matter, and not fall under Section 3 of the Patents Act. Right? We'll come to everything. The patent search is done to determine novelty. What is a novelty? An invention is considered to be new if it doesn't exist anywhere in the art, in literature form, in spoken form, in tradition, anywhere in the world. It shouldn't exist. So for an invention to be considered as new, it should not form part of a state of the art. It should be novel. It should not be anticipated by prior knowledge in public domain, either by way of prior publication anywhere in the world, or by prior use in India or anywhere in the world. If it is used even in Africa, you can't get a patent for it in India. Nowhere in the world it should be used or known. So novelty is that. It shouldn't have fallen in the public domain. Patent search. What is patent search? Patent search is a search of the patent database as well as non-patent database. See, patent database will consist of only patent applications, patents granted patents of all those inventions for which patents have been filed. There are many inventions which haven't been filed for the patent. So we have to search in non-patent database also. अभी तो बहुत अच्छा है, Google है हमारे पास. You can search everything in Google. So you have to do an exhaustive search before you are sure that your product is novel or your process is novel. So you have to search in patent and non-patent database to determine if there is or there are any similar patent applications or inventions which is to be patent. And it is not compulsory. आप करो या ना करो, the patent office will search. Whenever you file a patent application, the patent office will conduct a patent search to determine if it is novel or not. So it is better if we do, so that we know beforehand that if it is not novel, why proceed ahead? We can alter the process, we can modify the product, we can make substantial changes so that it can go ahead for a grant. Why is patent search done? To evaluate if the invention to be patented has been disclosed or published anywhere in the world, and to help inventors decide pursuing patent filing or modifying the invention. That's what I said. You can modify it. पहले से patent search करो. If your concept is ready, na, you have to, before developing the prototype or putting in money in it, first do a search, novelty search, prior art search, so that you are sure that no, my concept is 100% new and I can go ahead for it. Otherwise, why waste your time, your efforts, everything, and your money? Right? A good search is a combination of exhaustive search and extensive search, for which a good search strategy is used on a good and relevant database. You have to search on a good and relevant database. Different types of search are there. Patentability search, that is the prior art search, which helps in determining the novelty of the invention. It is the most common search, and it is conducted before preparing the draft of the patent application. Because if already a patent or similar invention exists, then you won't get a grant for it. Freedom to operate, non-infringement search. This is another type of search. Why it is done? If you want to make a product or you have developed a process and you know that there is a patent or the patent application present, so you have to check that is it infringing that patent or that patent application, because if it is infringing, you are in trouble. So it is better you have to first check it out that is it similar, how my invention is different from the existing application or patent, so that you aren't infringing the claims. It is mainly done by the industrial people, because they make, suppose drugs, they make a formulation, and someone has patented it, then they are in big trouble. So it is better to first conduct a freedom to a non-infringement search and then proceed for the commercialization. If infringement is established, commercialization is amended, or invention is redesigned so that you don't infringe it. Or else you have to, if you have to make the same product or use the same process, you have to approach the patentee and ask him or her for licensing it to you, right? It is mainly conducted for 20, it is like a search, this search is done for a period of 20 years because a patent's life is not more than 20 years. So if you are making a similar product or processes which has for which patent has been applied for before 20 years, then you are not infringing it because it has already lapsed. It's over. Its time period is over. Validity search. It is done by companies. Like suppose there are two rival companies. One has been granted a patent for a product, and the rival company says, "Nahi yaar, this won't do." So what they do, they will try to validate if the patent is proper or not. They will try to find out some problems in the patent so that they can oppose it and make it invalid. Right? This kind of validity search is done for it. Also, it is done if accused by patentee of infringement. If someone says that the patentee is infringing, the patentee will also do a validity search because he also wants to confirm that I am right. Landscape search. It is a broad search. Like what is, if some PhD student wants to start, if you want to take up a new topic of research, you should know now what is the R&D going on in this field, in your field. So for that, landscape search is done before any concept is developed or before something is planned. So it gives potential ideas to inventors during the R&D. And it also provides a snapshot of the patent situation. What is the situation? Others are the state-of-the-art search, which like if you want to work in a particular field, if you have decided, then you should know what is existing in this field, what research has already been done, so that you can carry it further, or you don't do exactly the same thing. Bibliographic search is for searching for a specific patent application, or if you have the number, similar. Continuing search just for awareness, for updating yourself. For if you are in a particular field and if you want to be updated regarding what is going on in this field. So you do a continuing search for keeping yourself updated. Assignment search is done to determine legal ownership of a patent. If someone is interested in taking exclusive rights or some rights for a patent, they do the assignment search. Number search, if you have a patent number, patent application number, you just put in, it is the simplest search, you put in the number and you get the application open. Name search, if you want to know how many applications have been granted for a particular inventor or a person, you can do a name search. These are the different search engines: Indian Patent Office, USPTO, EPO, WIPO, JPO, Japan Patent Office, Google Patent Search. All these are other searches available. So now, how do we turn it into the... Now let us discuss some invention. कोई मुझे बताएगा something for which we'll do the search? Yeah. I didn't get you.
IC layout.
IC layout. Okay. So you are saying about IC layout. No? Yours is? Controller. See, from these which I have received. Okay, we'll go this simple one, real-time hemoglobin level measurement. Can I discuss here? Okay. So you have this. You have given this to me, real-time hemoglobin level measurement system. Now, how do we search it? पहले keywords बनाओ. What keywords will we make? पहले मैं कहीं पे type कर दूँ. Everyone has this. You write down this topic: real-time hemoglobin measurement system, hemoglobin level measurement system, and give me the keywords for it. A list of keywords. What will you write? And you also have to speak out loudly. We'll first start with our own Indian Patent Office.
Yep.
In Google, you can type Indian Patent Office for accessing the Indian Patent Office. See, this is the official website of the Intellectual Property India.
Hello.
It is www.ipindia.gov.in. Right? Now, in this, we have this public search. You get here? You are with me? Right? We get into this public search. Public search of patents we have to do, right? We go into the patent section. It is an external website, yes. Now, there are two sections of published patent applications or granted patents. We have to enter any search for if you have a basic concept ready or something ready, you have to start with the keywords of the invention. You have to define such keywords which are general also and quite specific also. Like yours is real-time hemoglobin level measurement system, right? So, what keywords will use? See, we can search in these many fields. I'll show you these. On the left-hand side, you can see application date, title, abstract, complete specification. You can search in these fields: application number, patent number, applicant name, applicant country, applicant address. With all these fields, you can search: inventor name, inventor country, inventor address, filing office, international patent classification, PCT application number, PCT publication number. All these fields are present. We should use at least 2 keywords to search. So we'll start searching in the abstract, because main what is an abstract? Or brief of your invention. So the brief will have to contain these keywords which you want to search. So we'll search in the abstract. Give me 2 keywords.
Hello. Yeah. So one of the keyword is Internet of Things, and another is real-time hemoglobin detection.
I want one word.
One
word
word.
and another word.
Hemoglobin.
Yeah, hemoglobin. And second one?
IoT or real-time. Real-time is one.
Only IoT.
IoT.
IoT and hemoglobin. Right?
IoT and hemoglobin. Yeah, no issue.
Okay.
That's same.
IoT, and then see, I have changed the search field for the first one. That was written title. I have changed it to abstract, right? Because we want to search 2 keywords in the abstract. IoT and hemoglobin. I made a mistake. Hemoglobin, right? Am I right? The spelling is correct. HAE आएगा या HE आएगा? HE आएगा, right? We'll go down. We'll put in the CAPTCHA code. Search. There is only one patent application with IoT hemoglobin. See, you got it. This application number is there. A wearable sensor-based customized menstrual cycle predictor. In the abstract of this application, there are the words IoT and hemoglobin. That is why this has appeared in the search. You can click on the application number and it will open here. You can get the details, the applicant, the field of the invention. You can get the applicants, inventors, everything, right? You can compare the abstract. You also can get the complete specification here. If you think the abstract is similar, then you go to the complete specification. In this way you can search, and if you view the application, here view application status is there. If you click on that button, the status is displayed. It is in the hearing stage. Right, hearing is going on. We can view all the documents online of this patent application. Whatever you want, details you want, you can search. Got it? अभी हम granted patents में देखेंगे. Right, we had this was the published one. Now we'll see in the granted one. Abstract में डालते हैं IoT. Hemoglobin aside. No, there is no granted patent for these two words, IoT and hemoglobin. But ऐसा ज़रूरी नहीं है कि आपने IoT और hemoglobin word use किया है तो the other applicant or the other inventor has used the same words. They may have used different words. We have searched for IoT plus hemoglobin. So we have to take many such keywords. We have to take similar same meaning words. For the instead of hemoglobin you take blood, instead of IoT you take real time. You have to change you have to take as many keywords as possible to search. Then only you can do the exhaustive search. Like suppose in the published application we'll take real time and blood. तीन भी ले सकते हैं. इंडियन पेटेंट ऑफिस में ले सकते हैं ज़्यादा. लाइक एट मेनी प्लेसेस ओनली 2 words आर अलाउड. एंड यू इंडियन पेटेंट ऑफिस में आफ्टर यू सर्च ना, अगर बहुत बड़ी लिस्ट आती है, इफ़ यू गेट अ लॉन्ग लिस्ट ऑफ IoT एंड hemoglobin, then you add a third word and you can keep adding so that you can concise it to your invention. Got it?
मैम हमारा मेथड जो है वो नॉन इन्वेसिव है. नॉन इन्वेसिव.
Not done?
बॉडी में कोई पंचर नहीं करेगा. Without taking blood, it will measure the hemoglobin of the body.
Yeah, so it's but you have to, like आपने ये बनाया है, but you have to search ना that someone else in the world may have thought about it. This is just Indian Patent Office. Indian Patent Office shows only Indian patent applications and patents. You'll have to search at other places also. So you got my point. You have to search using different keywords for any invention, not just real-time hemoglobin measurement. For all inventions, if it is a mobile phone, you suppose the basic thing, mobile phone. You use mobile phone. Then you use portable telephone, portable handheld device. So you can use so many things. You have to use as many keywords as possible for search, so that you get a exhaustive search, so that you can get a clear picture. हाँ, मेरा invention नया है. My invention is totally new. I can go ahead for patenting it. Got my point?
Yes, ma'am.
ये Indian Patent Office हुआ. Now we'll search in. We'll go to WIPO. Google में डालो WIPO. WIPO आया. WIPO में directly go to the patent scope, because for searching, patent scope is the database for searching, patent searching. We come to this page, access patent scope. यहाँ पे you can write terms in continuation. It searches on the first page. WIPO searches on the first page of the document. So it will include the abstract, the title, applicant's name, inventor's name, everything. All these will be searched. अब यहाँ पर लिखते हैं राइट IoT एंड हीमोग्लोबिन. The same one has come. See, there aren't many inventions in this field. You got just a single one. So that's very good. नहीं तो competition बहुत होता है, लंबी list आ जाती है. So you have to go through each and every one and you have to find the differences. नहीं, how mine is different from the rest, and then only you can go ahead. It's good. आपको एक ही रेफर करना है. You can refer this and go ahead for the filing. Yeah. Yeah. Okay, let's see. हाँ, मैंने गलत स्पेलिंग लिख दी. Yeah, how many you have got? 176 results you have got. But कितनी बार क्या होता है कि these things ना, they make such a wide search, real time or hemoglobin is taken, or real or time or hemoglobin. These things are taken. So many times when you search with such at such open day, what happens so that you get so many searches which are totally irrelevant. So just go through the abstracts and then move ahead. In such cases, just go through. Like first title पढ़ो, multi-channel cupping system which enables simultaneous real-time measurement of hemoglobin. Yeah, it may be similar to your invention. So you have to go within it. इसके अंदर जाओ. You get this abstract and you also get the application number. You have to open the whole document. You can see the description here. It is in Korean, so you'll have to translate it. You get the machine translation here. Got this? अलग है. Like this way you have to go through each and every document. अलग है, वो बहुत अच्छी बात है. Yeah. Pricking होता है. हाँ. So this is without puncturing. Yeah, that is good. And और भी आए हैं. So like this one, the system method and computer program product for screening a spectral image. Now this is in no sense related to real-time hemoglobin measurement system. But आ गया है because कहीं कहीं कुछ words use हुए हैं. So we have to go through all this. जो भी similar लगता है, read the whole document and find out the differences between your invention and the document which you have got, so that you are sure that your invention is novel. WIPO includes patent applications of many countries, so you can get a lot of applications within this. देखो, Korea, US, Australia, WIPO, China, everything is here. Right? So you can search, like it is you have a main search if you want to do worldwide. Google search to hai. Apart from that, you should search in WIPO and European Patent Office. European Patent Office also has patent applications of many countries of the world. तो आपको इंडियन पेटेंट भी वहाँ पे मिल जाएगा एंड ऑस्ट्रेलियन भी मिल जाएगा, चाइनीज़ तो सभी मिल जाता है. It is a very broad search engine. You get everything there. वहाँ इतना सारा मिलता है ना, we have to go through each and every document for doing the search. बहुत एग्जॉस्टिव होता है. सो गॉट इट. वाइपो में ऐसे सर्च करते हैं. All others also, your inventions, you find out the keywords and search in this manner. Right? Now, क्या देखेंगे हम? यूरोपियन. पेटेंट वैलिडेशन ये रहा. हाँ, ये देखो ई स्पेस नेट. ई स्पेस नेट इज फॉर पेटेंट सर्च. वी शुड डायरेक्टली गो ऑन दैट. We'll open the classic eSpaceNet because for basic search it is very good. Here you can search using the keywords, application number. If you want to search a US patent also, if you write US and the application number or the patent number, you can get the whole document from here also. You don't have to go to the USPTO website. अब कोई और बताओ, कोई और कीवर्ड. आप लोग तो सब इन्वेंटर्स हो. So should I write Anulom Vilom?
Yes.
Let's see. अनुलोम विलोम से तो कुछ नहीं मिल रहा है. ब्रीदिंग एक्सरसाइज you'll have to search for. Yoga, breathing. Right? Yoga, breathing exercise. We'll search with these words. There are 14 applications. Massage cushion, yoga physical therapy system, then the pilot's fall and pilot's fall system using the same beauty method. Suppose आप इसमें से कोई ओपन करती हूँ, कौन सा ओपन करो? Deep breathing method. Okay, deep breathing method. This is a Russian patent application. Deep breathing method. You get the inventor, applicant, classification, application number, priority number, and the abstract. हाँ, देखो हम इंडिया में नहीं होता है. But in other countries of the world, even software is patented, even everything is patented. India is quite strict regarding patents as compared to other countries of the world. In the other countries of the world, you can get patents easily, but Indian Patent Office is quite strict, and it has many, like you may have, in the previous sessions, you may have gone through the non-patentability criteria. नहीं तो drafting के time बताती हूँ. So there are many rules. There are many things they have strictly mentioned that we aren't going to patent these many things. बाकी सब जगह ऐसा नहीं होता है. बाकी जगह तो it should be novel, inventive. They'll give a patent for it. India has many strict laws for the same. So now if you want to get the whole document, description or claims मिल जाते हैं. You can see the description here.
कम पेटेंट्स मिले हैं तो सॉरी अगर बहुत ज़्यादा पेटेंट्स मिले हैं तो वी कैन अंडरस्टैंड कि हाँ ये कहीं ना कहीं होगा.
हाँ, नहीं
इंडिया में
ज़्यादा डिफिकल्ट है. बट इट इज़ नॉट, यू कैन इंक्रीज द नंबर ऑफ कीवर्ड्स. ना, अगर इंडिया में आपको सर्च में बहुत सारे पेटेंट्स मिले हैं, ऐड मोर कीवर्ड्स विच आर स्पेसिफिक टू योर इन्वेंशन, तो कम होते जाएंगे. राइट. सी दिस इज इन रशियन. यू कैन ट्रांसलेट इट टू इंग्लिश. You'll get its English translation, the whole description you can get. You can even get the claims for it. Claims. This is they have a single claim. You can go through the claim and then you can determine if your invention is different from the one claimed here. Then you can go ahead for the patent filing. Got it? Now, और क्या देखना है? You have some other things to be searched. मैं आप सब लोगों का प्रायर आर्ट सर्च करके दूँ.
Yeah.
What you use? Like if you have a, give me some keywords. Device to measure the, I didn't get you exactly. Device to measure the range of motion, rate of motion, motion measurement. Right? Human motion measurement. We are getting so many results, 955 results. Now, एक देखते जाओ. Motion sensor modules, computing device, head rotation motion, self-adaptive, non-contact, robust, heart rate detection method. Like this one, the fourth one, human body motion posture measuring system. This is a Chinese patent. You can go through the abstract. If the system is different from yours, you can, like, you are the best judge for determining the keywords of your invention. आपको ही पता है what is your invention. So what are the important words in your invention? Now here if I have written human body motion, instead of motions you should also use the word movement, because movement भी आएगा. Then instead of human कोई man लिखेगा, like man लिखेगा या people लिखेगा, public लिखेगा. You have to use all those keywords, because someone may have not mentioned the word human, someone may have not mentioned the word motion, पर वो abstract में movement word है instead of motion. So you have to use all types of words to find out the similar inventions. Only after doing that you can determine the novelty of your invention. Now what you want to do? बोलिए सर. That is very difficult.
Based on that, whether we should file patent or not.
See, non-obviousness is a very difficult thing to determine, because only the inventor can say he or she is of that field.
Yeah, but in our case, most of every inventor saying that this is a very innovative approach.
It is an
we get lots of documents also, but it's very difficult for us to whether we should go for the patent filing or not.
See, inventive step is very difficult to determine, and in the patent office also, in every examination report, inventive step is questioned. Everywhere they question inventive step. We have to then justify. We have to give justifications how the cited documents are different. What is the inventive step in this invention, in the proposed invention? So determining inventive step is very different. We should know, the inventor should know कि ठीक है, this is novel. You have determined novelty, prior art search से मिल गया. Now you done some technical thinking and a technical output कुछ है इसमें? Have you added something to the technology which is already existing? Like this here his invention on real-time hemoglobin level measurement. So hemoglobin level measurement systems are available. What he has added, is it something which for which he has to use his brains? No one can directly think of it. कोई भी सोच सकता है, नल में पानी नहीं आ रहा है, भाई पंप चालू कर दो, वो कोई भी कर देगा. That is quite obvious. But पानी नहीं आ रहा है, तो what alternate you have thought? Has it some technical input? कुछ technical होगा, advancement होगा, technological advancement, then only the inventive step is determined. And in most cases, this inventive step is questioned by the patent office, and we have to prove that it is inventive. Mostly hota bhi hai, because people, they are researchers. Those researchers have done something new. Then only they come for a patent. हाँ, industries में कभी-कभी ऐसा होता है कि they pick up something and ठीक है, डाल लो patent. ऐसा नहीं होना चाहिए. Researchers तो they are evolving. They do research and they come to some invention. So there has to be something technical input. But कितनी बार ऐसे होता है कि the inventor is not able to explain what is his step, what is his inventive step, what is his technical contribution to the invention. We have to, हमको खोदना पड़ता है बैठकर, नहीं बताओ ये कैसा different है. Have you added water? Have you added methanol? Have you done it in 20 minutes instead of that 1 hour? एक एक क्वेश्चन हमको पूछना पड़ता है for determining the inventive step. How much better it is than the previous closest prior art, previous technology available. How much better it is, we have to determine, and then we can decide the inventive step. होगा ही, in research situations mostly inventive step होता ही है, because they have worked, they have done some research, so they have done given some technical input. It has to be, but we have to find out, and we have to convince the patent office also. They always question on this. नहीं तो वो section 3 का line डाल देंगे, that is not patentable under section 3D, section 3E, everything, and you have to give justifications for the same. But the better justification you give, the more chances are there for the grant. Right? अब क्या करें? What you want to search? Design search? ये तो पेटेंट का सर्च है, डिज़ाइन का नहीं है. Actually, I don't do design applications. I do pure patent applications. On the patent office website, you can go for the design, search designs, and in that you can search for it.
कोई व्यक्ति और कंपनी के नाम पे है पेटेंट, तो उसको कैसे सर्च करें?
You can see ना, जैसे ये है, समझो ह्यूमन मोशन मेजरमेंट, ये आपने देखा. You have searched this. See, the inventor name is given. The applicant name is given. Applicant is Finch Tech. So Finch Tech is a company, and the inventors are always natural persons. They are individuals. So these may be employees of this company or whatever, R&D team or whatever. But the applicant is a company. In the second also, applicant is a company. Third, fourth, यहाँ सब जगह applicant companies हैं. In India, the scene is different. See this, the 12th application. The applicant is an individual person, Zhang Shuo. Inventor is the same. He is filed as a natural person. क्या किया है means you can go through the whole patent ना.
Ma'am, the question is, can we search patents given by a person with person's name? Like search में नाम डाल देंगे तो आ जाएंगे क्या patents?
हाँ, वो भी आ जाएगा. इसका नाम डालो. इसके नाम पर पेटेंट है.
मेनका गुंडानी. MEN. KA GUR स्पेस डाल के GUR NANI मेनका गुन्नानी
Gulnani. There isn't any application.
स्पेस मेनका इज नेम एंड गुन्नानी इज सरनेम.
जी से पहले स्पेस है.
ओके, जी से पहले स्पेस, राइट?
MENKA हिड्डा लाइफ साइंस LLP करके उनका कंपनी का नाम.
क्या नाम है?
MENKA.
मेनका, राइट?
MENKA GUR NANI.
There is one purification process for lipopeptides. Is this right?
Yes.
Okay, Cadila Healthcare के हैं. You can search in the applicant's name, the inventor's name. The first page is checked in European Patent Office and the WIPO. In both these cases, the first page is checked when you do the simple search, and any name, if the applicant is a company, if you write Cadila Healthcare, you'll get a list of patents or applications from Cadila Healthcare. You can search in that, and you can search using the keywords. Right? अब क्या करना है? You have got, everyone can understand, have understood how to do search, patent search. तो मेरे पास जब ड्राफ्टिंग के लिए लेके आओ तो सर्च करके आना. Offer?
I'm saying, can you give an example of a keyword for which there is no result? Means something really
For
new.
which there is no result. We had searched, na? Huh? Anulom Vilom.
Okay. Yeah, but that I think because of Hindi word or something,
Yeah,
right?
there's also in these words. पर उसकी जगह हम जैसे लिखेंगे something totally new. अब इसमें भी थोड़े तो आएंगे. इसमें 0 आया. अच्छा, वो स्पेलिंग रॉन्ग लिखा था मैंने.
IoT and hemoglobin, right? But I think there are products in the market with this kind of thing, right? So why it is giving 0 result?
Products may haven't been patented. Patent application file नहीं हो. They haven't. If the patent applications have been filed, they haven't used these words. So there
I
isn't
think
any.
there is one company incubated at IIT Delhi. They were doing something with this, if I remember it correctly.
They may have used the word blood instead of hemoglobin.
Yeah, something,
They may
yeah.
have used the word.
So keyword might be different,
No,
but still
that
it
is
may
why
have
I'm saying that the keyword, you have to use all the keywords which.
So I'm saying that that's why. So basically, if somebody has invented something, I think probably these databases are not very well designed to serve the community, right?
Sir,
Because you see, normally ideas comes as a thought process, right? And person should be able to search the really thought, whether that thought is there or not.
Yeah.
Since the database is based on keywords, it will not work actually all the time.
But no, sir. Like you have to use all kinds of keywords. Na khali IoT hemoglobin use karenge. It is not necessary that everyone thinks that.
But what I'm saying is sometimes the thought may not be expressible in the enough keywords which can fetch you the result.
Yeah. So that is why we have to use many keywords. Instead of that, if we write this, we get a list of patent applications. Real time is through IoT only. But किसी ने IoT नहीं लिखा है. They have used real time. Instead, if we use the word non-invasive, as you said, then also we'll get lots of applications for the same.
But I think, so I have another question. So suppose I find a keyword which is not there, and I ask ChatGPT to prepare a patent application or something like that, then will it be patented, or whether somebody has tried it?
So actually what happens? What happens if research has been done properly? If you have done research, then you know what is the prior art. What research has been done.
No, actually, sometime what happens, actually, what I'm saying, if the idea is really disruptive, or so sometimes then there is nothing available, and then still you have to claim that it is new, right?
Yeah, and
so-
then in the examination, when it goes in the examiner objects that there are similar
How can
inventions.
they say because there is nothing?
They may have used different keywords. Like what happens, the abstract, जैसे अभी IoT के लिए था कि IoT किसी ने नहीं use किया, but real time people have used. They have used invasive word, non-invasive word. So we have to search. एक में IoT में नहीं मिला, it doesn't mean that your invention is 100% novel. You have to find. वो भी एक
No, but I'm saying, that's why I'm saying, ChatGPT can use some sort of data, right?
Yeah.
If I ask it to generate a patent application for me for some certain keywords, so maybe something may click, right? I don't know whether somebody has tried it or not.
सर यहाँ पे तो नहीं मिला इंडिया में तो, बट लाइक देयर वाज समथिंग इन सम डिस्कशन recently. Some AI has got patent granted in his name, in its name, in US.
Okay.
And there was a lot of uproar that how is it possible you can give a patent grant to individuals only, but AI had created it, so it had been filed in AI's name in the.
Okay.
In
so
that
there are
name.
results like that, yeah.
But
in India we have no preparation
in
like
India
that.
ऐसा नहीं हुआ है अभी तक, but in US it has happened. And after it was granted, it came in the newspapers also कि how can a grant be given to a machine? But the patent office said that the invention is there. We have to grant it.
Okay. Thank you.
I don't think so, because India में क्या होता है कि when you file a patent application, either it is a natural person or it is a company. Company में भी you have to give the name of the inventors and everything. So if you haven't some humans as names of inventors, you have to not just give the name of inventors. You have to give their addresses, their details, everything, email address and everything. तो AI का कहाँ से देंगे हम? उसके बगैर पेटेंट एप्लीकेशन फाइल नहीं होता है. You have to enter all the details. That is why.
In India it will be not acceptable.
I also think so.
Hello, ma'am. Sometimes like assessors also they use the same methodology, right, for checking our novelty or non-obviousness and all. So whether they can also bypass this type of, or there may be some misunderstanding, like sir said, कि just put a word which doesn't show any search, or there is zero result.
See,
So
if some words have been put due to
like government or IPO has some certain mechanisms like to avoid such things, like use of AI also maybe just for assessing, I'm telling, not for generating something.
See, हम लोग if we file a patent application, we use some words, and however best search we do, then also the patent office comes up with new inventions, new documents similar to your invention. But that doesn't mean that they are similar. कितनी बार तो they are very unrelated also. We have to give justifications. We have to show, and the inventor, like in my case, whenever I get an examination report of any applicant, I consult the applicant. I give him some work that you find out. You give me the differences. You show me what is different, because he is the inventor. He knows the invention the best. If I search, मुझे maybe कोई field का ज़्यादा पता हो, कोई field का नहीं पता हो. I am not a good judge for all, a good scholar in all the fields. So the inventor is the best person who can show that how his invention is different from all others. And then you can get a grant.
Okay, thank you.
I think you are not still confused.
No, just like there are mechanism for plagiarism checking and like such
There
type
are
of things.
mechanisms, सब
So
होता है.
I was just wondering that whether IPO and other like WIPO also they have certain mechanisms.
See,
Yeah.
so, there are many methods, everything is there, but जो true inventor होता है, true invention होता है, तो they are going to get a grant by hook or by crook. Like not by crook, by true means only, by real means only. अब किसी को कुछ और पूछना है, सर्च करना है और कुछ?
Ma'am, I have one question. So, is it always compulsory or necessary that whoever is going to patent a file, it should individual should be related to some institute or organization or
नहीं,
independent?
नहीं, in
like-
India there are many people who file as an individual. In India, many individuals file patent applications on their own name. You may be astonished, many housewives also, they do not work in any field. मैंने हांडवे की रेसिपी का भी पेटेंट देखा है. It is made, the recipe is made in a different way and she has claimed protection for it. So, like, it isn't necessary that you are associated with any company. And company people also, छोटी companies होती है ना, तो they think it better to file in their own names. Because what happens, the company may exist, may not exist. If the patent is in their own name, they can, if the company doesn't exist, they can sell it to someone, they can do some other work. That is why individual names for patents बहुत ज़्यादा होते हैं. Institute companies भी होते हैं, but और कुछ सर्च करना है? Should I close it? Similarly, you can search in other patent offices also, Japan, SIPO. Where is my presentation? US Patent Office. Yeah, you have anything to ask? Keywords for invention. Suppose if you have a mobile phone, you can have to use different words: mobile plus phone, cell plus phone, cellular plus phone, hand phone, portable telecommunication device, portable electronic device, handheld communication device, handheld electronic device. So many keywords can be found, and you have to search with each of them so that कहीं से भी कुछ भी रह नहीं जाए. You search every corner. Plurals should be used. They should be searched in patent title. First, you search in the abstract. Then you, after you find similar inventions, go to. If you find similar inventions, go through the complete specification of that invention so that it is easier to establish the novelty of your invention. कुछ पूछना है?
How to write a patent?
Write a patent next session है ना? So, continue करना है या?
Thank you, ma'am. We have 15 minutes tea break. So join us for tea at LT4. Thank you.
I'm sorry for the delay. The tea is now available. You can have it. Thank you. Hello again. We are resuming the talk. Now I invite Ms. Kavita Shah for her session on patent proposal writing.
Okay, done. Hello everyone. So now we'll do the session for patent drafting. Brief पहले जान लेते हैं what is qualification of a patent, exclusive right granted by the government to the applicant or his assignee for his disclosed invention of industrial product or process which should be new, non-obvious, useful and patentable. Right? What is an invention? As said earlier, this is the same slide for an invention. Novelty हमने देख लिया, how we should establish the novelty through prior art search. If we do the prior art search, we can establish the novelty of an invention. Inventive step. Inventive step is also very crucial. What happens in most of the patent, in most नहीं सभी में, in all the patent applications filed, the examiner is bound to question the inventive step of your invention. That what technologically advancement you have done, which wasn't existing in the prior art. What technical inputs are there of your invention? Inventive step means that it is not enough that the claimed invention is new. It is different from what exists in the prior art. But difference must be clearly visible, clearly noticeable, showing progress over the prior art. So there should be some inputs from your end. There should some problem must have been there with the prior art which you have solved using your invention. That is the inventive step of your invention. And capable of industrial application means it should be capable of being used or made in the industry. Right? Like कुछ भी useless चीज़ के लिए patent नहीं मिलता है. If you say I have a new thing and which has inventive step also, but it isn't useful to anyone by no means. तो why have you invented it? उसका ज़रूर क्या है? You don't need it. So it should have some use in the industry. Whenever you have an invention, you should be clear that it doesn't fall under the non-patentable inventions. Section 3, as I said, Indian Patent Office is quite strict. Section 3 of the Patents Act specially defines which inventions are not patentable. So you have to determine that your invention doesn't fall under all these subsections of Section 3, any of these subsections. And for 3 is an invention which is frivolous. Have you gone through all this in the previous sessions? Yes? So just you know, right? Frivolous inventions are not granted patent, then contrary to public 3B, contrary to public order or morality. भाई वो नहीं बीच में आया था चप्पल बनाए थे भगवान के फोटो वाले तो this is contrary to public order morality. Third is mere discovery of an abstract principle is not patentable. Mere discovery of a new form, कोई solid form है उसको आपने liquid form बनाया, same composition है, it is not patentable. Admixture, if you mix 2-3 things and the resulting isn't any synergistic, the resulting mixture isn't it is just an aggregation. कुछ synergistic form नहीं होता है, कोई synergistic result नहीं मिल रहा है. It is not patentable. Mostly sections 3D, 3E and 3F में बहुत ज़्यादा objections आते हैं because the examiner says it is just a duplication or a mere mixture. It is an arrangement, rearrangement. We have to show them that our invention, like if you have added the camera to the mobile phone, so the camera is working along with the mobile phone. That you will have to show. If you are claiming the mobile phone with a camera, you should show that it works synergistically. Both of them work together. It is not just camera is working independently, mobile phone is working independently. ऐसे नहीं होना चाहिए. 3G is omitted. H method, agriculture, horticulture method is not patentable. Then process for medicinal, surgical, curative. All these processes are not patentable. But if you have made some device for surgery, if you have made some kit for diagnosis, that is patentable. Some therapeutic kit you have made, the processes won't be patentable. How the kit works won't be patentable, but the kit will be patentable. Diagnostic kit or a surgical instrument, all these are patentable. Plants, animals can't be patented, or seed varieties, microorganisms, anything which is natural can't be patented, which occurs naturally in the nature, it can't be patented. मैथमेटिकल बिजनेस मेथड कंप्यूटर प्रोग्राम 3K आता है, जो भी IoT रिलेटेड इन्वेंशन है सब में 3K का ऑब्जेक्शन आता है. इट इज़ अ कंप्यूटर प्रोग्राम, सो इट इज़ नॉट पेटेंटेबल. यू हैव टू जस्टिफाई कि आई एम नॉट राइटिंग द क्लेम्स ऑफ कंप्यूटर प्रोग्राम, द क्लेम्स आर ऑफ द हार्डवेयर. आई एम नॉट क्लेमिंग द सॉफ्टवेयर पार्ट. 3K का ऑब्जेक्शन विल कम इन ऑल कंप्यूटर रिलेटेड इन्वेंशंस, राइट. 3L इज़ लिटरेरी, ड्रामेटिक, म्यूजिकल, आर्टिस्टिक वर्क, वो सब कॉपीराइट में आता है. M is mere scheme or rule or method of performing mental act, something which is playing in your mind, some mental act, method of playing game, all these are not patentable. Presentation of information, this presentation will be copyright protected, not patentable. Topography of integrated circuit will go in protection of integrated circuits. And traditional knowledge. These are the sections, all the subsections of section 3. All these are not patentable. So whenever you think your invention is complete and is patentable, you have to confirm it doesn't fall under any of these subsections. No patent is granted for atomic energy related patents, related inventions. Patent filing procedure. What is the process? Any person who is a true and first inventor or his assignee or legal representative is entitled to file for a patent. True or first inventor can file as an applicant. Assignee, if you are working for a company, for an institution, the institution is the applicant and you are the inventors. Or the legal representative, if you have given the rights to someone, they can file for the patent. Either alone or jointly with other person to protect his invention. There can be one individual, there can be two individuals, there can be 10 individuals filing a patent. There is no such restriction in the Patents Act. How many people together can file a patent. एक मैंने एप्लीकेशन ड्राफ्ट की थी, 10 एप्लीकेंट्स, 10 का नाम एड्रेस लिख कर हालत ख़राब हो जाती है फॉर्म्स भरते हैं तब. द एप्लीकेंट हैज़ टू इंश्योर दैट द एप्लीकेशन फॉर पेटेंट रिलेट्स टू अ सिंगल इन्वेंशन. यू कांट मेक लाइक टू, आपने इफ़ यू आर वर्किंग इन द फार्मास्यूटिकल सेक्शन 2-3 फॉर्मुलेशंस बना दिए, सब कुछ एक ही पेटेंट में डाल दो, खर्चा कम, ऐसा नहीं कर सकते हैं. यू हैव टू फाइल इंडिविजुअल एप्लीकेशंस फॉर ईच invention. All formulations are different, so you'll have to have filed individual applications for each formulation. If they are related, if the formulations are related, like the main ingredients are the same and you are changing the excipients, so you can put it in a single application. But if main ingredients are different, then you can't put it in the same application. The form prescribed is Form 1. It is all forms are available on the Patent Office website. Form 1 is for filing a patent application. The Patent Office website is www.ipindia.gov.in, as I showed earlier. You have to apply in your respective jurisdiction. अभी तो online होता है mostly, so the jurisdiction is decided automatically. You just have to put in your address. Documents. What are the documents necessary? Form 1 is the main form for filing for a patent application. Provisional or complete patent application, it comes in the Form 2. What is a provisional patent application? If your invention is in the process of being completed and you think that someone may copy it, or if you want to test it in public, first file a provisional application giving the concept of your invention. When the concept is, the concept will be protected from the first date of the provisional application, and then you get 1 year's time. In 1 year, provide the complete details, the tests you have conducted, all the details you can add and complete the application and claim the invention for which protection you require. You require an abstract, statement and undertaking regarding foreign filing. What happens in this? If you file a patent application in India and you want to file in any other country, you can file, but the same application, but you have to keep Indian Patent Office informed that I have filed in this country within 6 months. If you file, suppose you have filed a patent application in India, and within 2-3 months you are filing a US patent application, then you have to inform the patent office, Indian Patent Office, within 6 months of filing the US patent application that I have filed this application. Even when it is granted, you will have to inform Indian Patent Office that this application I had filed here and it has been granted. It is done in Form 3. In case of provisional application is filed first and then the complete application is filed, then you will have to file a declaration as to inventorship also in Form 5, that these are the inventors of my patent application. It has also to be filed. Request for early publication is optional. It has to be filed in Form 9. For what happens, all the patent applications after 18 months, they are published in the Patent Office Journal. But if you want to go for a speedy process, you can file a request for early publication. When you file this request, within 1 month, it gets published in the Patent Office Journal, and then it proceeds in the queue for examination. Otherwise, it will be published after 18 months in the Patent Office Journal, and then after that, it will go in the queue for examination. So your grant process will be delayed. In case of convention application, a certified copy of the specification filed earlier has to be submitted. Duly stamped power of attorney. If you are filing through a patent attorney, you will have to give a power of attorney on Form 26. Then Form 18 is the request for examination. Form 18 is compulsory. For all patent applications filed, you will have to file a request for examination. Otherwise, it won't be examined by the patent office. Right? There is another thing provided by the Indian Patent Office, request for expedite examination. The expedite examination speeds up the process. You have to pay excess fees for it, and then in a few years back, patents used to be granted after 5, 6 years. Even I have patent applications of 2013-14 pending with me. They haven't been granted yet. But 22 की भी grant मेरे पास 5-6 आ गई है. So when you file for the expedite examination, within 6 to 12 months, mostly the prosecution process is completed and the application proceeds for grant. Fees can be paid by cash, electronic means, or bank draft. This is the fees, government fees, which are applicable for the first application for the grant of patent, 1600 for natural person, startup, small entity, eligible educational institution. Others, like for the companies and everything, it is 8,000. Similarly, other fees are there. For patent office gives you 30 pages for filing a basic application. If your application exceeds, you have to pay rupees 160 more per page for the natural person, and 10 claims are allowed. More than 10 claims, you have to pay more fees for the same. Request for early publication is optional, but it is minimal fees for individual startups and everything. Request for examination, expedite examination. If you pay for expedite examination, you don't have to pay the fees for request for examination. 4,000 is for examination, 4,000 for expedite examination. Right? Filing of a patent application. Ordinary application. The first, what is an ordinary? We all mostly file an ordinary. The first application which we file is the ordinary patent application. It is filed in the patent office without claiming priority from any other application. पहले हमने कोई application उसमें file नहीं की है वो context में वो concept का. तो it is the first application without claiming any priority, without any reference to any other application. It is an ordinary application. It is either provisional, as I said earlier, or complete. Provisional. These are the contents of a provisional patent application. क्या क्या होता है? You have to give a title of the invention. ये सब हम डिटेल में डिस्कस करते हैं. Like just this is an index. कि provisional patent application में ये सब होता है. Right? Title, name, address, nationality, preamble, field, background, object, summary, detailed description. Drawings and claims may not be included in a provisional application because provisional कब होता है? When your concept is ready, your final product or process isn't ready. So you don't have to give the drawings or the claims. Claims कब होंगे? When your final invention is ready and you are claiming that I want protection on these things. So that comes with the complete application. Complete application needs to be filed within a period of 12 months from filing provisional application. What is a complete application? A complete application should fully and particularly describe the invention and its operation and use and the method by which it is performed. It discloses the best method for performing the invention which is known to the applicant for which he claims protection. Complete application, you should give everything, all details of your invention in the complete application. Even the data you have obtained for the trials, field trials you have conducted or anything, all the experimentation you have done, give everything in the complete patent application. क्योंकि क्या होता है, afterwards they ask, how do you say that you have achieved this result from your invention? तो provide the data, पहले से ही दे दो. All the data you have to provide and do not think that मैं ये छुपा कर रखूँ, my invention will go in the public. If you hide something ना, you won't get protection for it. वो part के लिए protection नहीं मिलेगा, कोई और वो use कर सकता है. Instead if you give it in a patent application, you get protection for 20 years. 20 years तक आप ही use कर सकते हो. And if anyone else tries, you can send him a notice. These are the contents of a complete patent application: title, name, address, nationality, preamble, field, background, object, summary, brief description of drawings, detailed description, advantages, claims, drawings, abstract. If a biological material is used, you have to deposit it at the International Depository Authority. If if there is a sequence listing of nucleotides, you have to present it in the electronic form to the patent office. First, अब पहले आता है title of the invention. What should be the title of your invention? Title of the invention में कभी भी don't use the words novel, new, unique. They know that it is novel, it is unique. That is why you are filing a patent for it. Title of the invention should describe your invention. आपने जो invent किया है, if someone reads the title, he should know that this is related to this field. You don't need to add some words like for trademark shouldn't add trademarked words for it or your company name for it. Don't add any such words. Fancy words नहीं चाहिए. They want a simple thing. If you have made a herbal formulation to suppose a herbal oil to protect from alopecia. You write it in simple terms. You don't say that, you don't mention a brand name. Suppose parachute oil for treating alopecia. Why add? You don't need to mention trademark anywhere or trade name anywhere. Give in simple language, simple words, the title. The title of an invention should be between 5 to 15 words. Usually it should describe the invention. कोई भी title पढ़े तो उसे पता चल जाना चाहिए. अच्छा ये मेरे field का है, नहीं है, go to the next. It helps in search also. Name, address, nationality of each of the applicants of the patent. If it is an institution, एक या दो institution भी collaboration में patent application कर सकते हैं. Individuals can also file, give complete name, address, nationality. Preamble to the description. These are there are two types of preambles. For the provisional application, the following specification describes the invention. For the complete application, the following specification particularly describes the invention and the manner in which it is performed. Why? Because complete application में सब कुछ होता है, all the details of the invention. So you have to mention the preamble. When you prepare the draft of your patent application, first give the title, then you have to, on form 2, you have to first give the title of your invention, then give the names and addresses of the applicants, then the preamble to the description. Either it is provisional or it is complete. Right? Field of the invention. Which field does this invention belong to? You have to mention in brief. If you are giving a herbal formulation, this invention belongs to the field of herbal formulation and provides a formulation for the treatment of asthma. like you should give some brief of the field of your invention. You don't have to search कि भाई हर्बल फॉर्मुलेशन कौन सी फील्ड में आता है पेटेंट ऑफिस में, वो पी क्यू वो सब नहीं चाहिए. दे डोंट नीड, दे विल डिफाइन इट देमसेल्व्स. You should describe what is the field. Background of the invention. Second comes the background. Background of the invention. What was there in the prior art? You have to say कि अभी तक ये सब था. You have to mention patent applications also which were there in the prior art before, and your invention is an advancement to these prior art. These are related to your invention. You have to provide. Like herbal formulation for treating herbal oil for treating alopecia. So you have to give that these are the herbal oils available in the prior art. फिर हमको ये भी बताना है कि what problem it doesn't solve. These are the oils, but they do not solve the problem of alopecia, or they are costly, or the blend is not proper. कुछ तो problem होगा. That is why you have made research in this field. So define the problem in the background of the invention. Give the background and define the problem. What problem was there in the existing prior art, right? Then comes the object of the invention. What is the object of your invention? Why did you make this invention? So you have to define. The main object of this invention is to provide a herbal formulation for treating asthma, which has this and this herbs in it, extracts of these and these herbs in it, which treats asthma from the roots or whatever. Like, what are the objects? You have to define 1, 2, 3, 4 objects of my invention, of each invention. आपने ये research क्यों किया? You must have some objective before you ना कि I have to. What is your aim? Whenever you write an experiment, you write the aim, then you do the experiment now. So what was the aim? That you have to write in the object of the invention. Then summary of the invention. In brief, describe your invention. My formulation contains this and this herbs which are extracted by in water extract or in methanol extract or whatever, right? And which I have added these excipients. Give a brief of your invention in the summary. Then you have to give a brief description of the drawings. Drawings provide करो तो better होता है, because क्या होता है, when you look at some figure ना, you easily understand anything. Even अगर कोई drawing नहीं है, कोई formulation है, you give a flow chart of the method of preparation, तो anyone can easily understand your invention. So drawings are an essential part. नहीं दोगे तो भी चलता है. It isn't compulsory, but it is better. When you see something ना, after if you read a long paragraph or 2-3 pages of the invention, the examiner will also get bored. But if a flow chart is presented na, he will easily understand what is your invention. That is why. Detailed description of the invention. Give all the details of your invention along with the examples wherever required. You need to provide all the examples of the invention. Like, what happens?
Ma'am, in the previous slide you mentioned brief description of the drawing. The drawing should describe the summary of invention or overall methodology.
Drawings, like if you have made some IoT, some circuit or something, some water treatment system you have made. Give a flow chart of the system.
End-to-end procedure right now from input to output, what is the system?
वो पूरा दिखाओ. If you have some tank, some product है, तो product का drawing दो. Give the drawing in a computer. Don't give hand drawn drawings. Give a computerized drawing. अभी accept नहीं होता है. Previously they were accepting it, but now they need computer drawings only. And you can give more drawings also, not just one. You can give more. Detailed description. Give all the details of your invention, everything you know about your invention. Write down everything along with examples. Examples, what are examples? एक formulation बनाया है. फॉर्मुलेशन में यू हैव टैबलेट बनाया है तो टैबलेट कंटेन्स दीज इंग्रेडिएंट्स and it is made by this method. First example. Second example, capsule. Capsule contains these ingredients, it is made by this method. Third, microspheres. Microspheres contain this ingredients, it is made by this method. Give all the possible examples so that everything is covered. कोई और कॉपी नहीं कर सके. Cover everything in your patent. सब कुछ आ जाना चाहिए. Advantages of the invention. After the description, you should give how your invention is advantageous, how it is useful, how it is better than the existing things, right? Then come the claims. Claims should be very properly drafted. It should have only the inventive things, the technology which you have invented. Claims should contain only what you have invented and for which you are taking protection. You will get protection only on the claims. पर claims में आपको prior art नहीं लिखना है. Claims में अगर आप first claim में लिखो कि समझो herbal oil, तो herbal oil containing 5 ingredients, these were available in the prior art, तो आपका reject हो जाएगा. You add the 6th ingredient also which you have added which wasn't available in the prior art, तो आपको protection मिलेगा. Right? You have to claim only the inventive features of your invention. Prior art को claim मत कीजिए. Claims, you have to write claims quite specifically only for the invention and write everything you have invented. ऐसे भी नहीं कि just थोड़ा brief लिख दिया. Write everything which is new, which is novel and inventive, so that you get protection for everything. Right? It should define the scope of your invention for which protection is sought. Drawings, as I said, drawings should be added. Claims and drawings aren't there in the provisional specification. It should be provided only in the complete specification. Even examples, जो complete detailed description में examples है ना, you need not provide them in the provisional specification. Complete में दीजिएगा, it will be accepted. Drawings, try to provide drawings. कुछ भी नहीं है तो give a flow chart of your work process. कुछ भी दीजिए. ड्राइंग्स आर मोर अपीलिंग एज कम्पेयर. ऐसा नहीं है कि यू मेक सम ब्यूटिफुल ड्राइंग्स, बट गिव वॉट इज देयर, द कोर ऑफ योर इन्वेंशन इन द ड्राइंग, डिस्प्ले इट. Abstract should be between 50 to 150 words. This is again a brief of your invention, where it is used, in what method it is used. Give that, because abstract is displayed with your bibliographic data. So whenever someone sees your invention, it first the abstract will be visible. So please give the brief details of the invention and how it is useful, so that a person comes to know कि भाई it is of my field or related field. कभी भी कोई पढ़ेगा, search करेगा, तो they come to know that this abstract, no, it is not related to mine, he can go ahead. Right? Okay, now we'll do some ड्राफ्टिंग वर्क करना है. कोई इन्वेंशन लेके आओ. किसका इन्वेंशन का ड्राफ्टिंग करते हैं? या कम आउट. ओके, ये स्लाइड रखती हूँ. चलो बताओ, आपका टाइटल क्या लिखोगे? आपका इन्वेंशन लाओ. व्हाट विल बी द टाइटल ऑफ योर इन्वेंशन? ओ बाप रे, आपने तो इतना बड़ा लिखा है. फॉर्मुलेशन एंड कैरेक्टराइजेशन ऑफ टैबलेट इन कैप्सूल सिस्टम, स्टैटिस्टिकल ऑप्टिमाइजेशन फॉर क्रोनोथेराप्यूटिक ड्रग डिलीवरी सिस्टम. इतना लंबा टाइटल नहीं चलता है. इट शुड बी विद इन 15 वर्ड्स, 5 to 15 वर्ड्स. तो यू कैन टेक दिस मच. फॉर्मुलेशन एंड कैरेक्टराइजेशन ऑफ टैबलेट इन कैप्सूल सिस्टम. ऑप्टिमाइजेशन वगैरह तो हमको लिखने की जरूरत नहीं है. वो यू कैन प्रोवाइड द डिटेल्स इन द राइट. सो योर टाइटल शुड बी 5 to 15 वर्ड्स. किसी और को बताना है अपना टाइटल, इन्वेंशन बताना है, डिस्कस करना है, तो हम उसका टाइटल बना देते हैं. चलो इस पर ही चलते हैं. नहीं करना है तो तुम्हारा कनेक्ट कर दो ना. फॉर्म 2 का तो आगे का मैंने बता दिया है. यू हैव टू राइट द टाइटल ऑफ द इन्वेंशन, द नेम, एड्रेस एंड नेम, nationality and address of the applicants, and then either is a professional or complete application. उसका preamble लिखना है, as I had said earlier, like I have given ना. कहाँ गया? ये तो सर्च आ गया. ओके. टाइटल ओके. यहाँ पर मैं टाइटल लिख सकती हूँ.
बैकग्राउंड में रख के अगर लिखना चाहिए, पब्लिश पेपर है उनको अगर बैकग्राउंड में रख के पेटेंट लिखना चाहिए,
लिख सकते हैं. बट लाइक पेटेंट कब फाइल कर सकते हैं? विद इन 1 year ऑफ फाइलिंग ऑफ द पब्लिशिंग. अगर आपको पब्लिश करके 1 year से ज़्यादा हो गया तो यू वॉन्ट गेट अ पेटेंट फॉर इट, बिकॉज इट विल बी देयर इन द प्रायर आर्ट. इंडिया अलाउस 1 year टाइम. नहीं तो पहले पेटेंट करो फिर पब्लिश करो. यू शुड ऑलवेज फॉलो दिस रूल. फर्स्ट गो फॉर द पेटेंट, देन गो फॉर पब्लिकेशन. रिसर्चर्स को हमेशा ऐसे होता है, पेपर पब्लिश कर दें, पेपर पब्लिश कर दें. बट इफ़ इट इज़ अ नॉवल इन एंड इन्वेंटिव आइडिया, फर्स्ट गो फॉर द पेटेंट, देन गो फॉर पब्लिकेशन. हाँ करिए.
उसमें ये इमेजेस वगैरह सब है. राहुल मिश्रा ऊपर से नीचे और थोड़ा धीरे बोलो.
मैम वी हैव 2 documents. वन इज दिस एंड एक दूसरा है ये जो उन्होंने भेजा है. ये दूसरा एक ये सर का है और ये दूसरा वाला जो है ये उनका है.
तो मुझे किसका का दिखाना है पहले?
इनका या आपको जिसका दिखाना है.
नहीं, लाइक आई डोंट हैव एनी प्रॉब्लम.
ओके पहले ये दिखा दीजिए.
ओके. तो लाइक मैं आई सेड दिस इज योर रिसर्च पेपर, बट research thesis or whatever. Yeah, thesis it is. But you can't give such a big title. So हम इसमें टाइटल रखेंगे formulation and characterization of tablet in capsule system, right? Because it describes the invention. Tablet in capsule system is the main thing of your invention, right? We can go with that title. उसके बाद क्या आएगा? After the title comes the name, address and nationality of applicants all the applicants, one or more applicants. You can file in your name or you can file in the institute's name, whatever is. हाँ एड्रेस आपका घर का एड्रेस दे सकते हो, वो आपको इंस्टीट्यूट का देना है दे सकते हो. लाइक मैंने इतने सारे एप्लीकेशंस फाइल किए हैं जिसमें मैंने लाइक प्रोफेसर्स ने कहा कि मेरा नाम रख दो, इंस्टीट्यूट का एड्रेस रख दो, तो कितनी सारी ग्रांट हो गई है. एक एप्लीकेशन में प्रॉब्लम आया कि पेटेंट ऑफिस ने कहा कि इफ़ यू आर फाइलिंग इन एन इंडिविजुअल्स नेम एंड यू आर गिविंग एन इंस्टीट्यूट एड्रेस, तो लाइक द एप्लीकेंट इज़ द इंस्टीट्यूट, इट इज़ नॉट द पर्सन. यू ब्रिंग NOC फ्रॉम द इंस्टीट्यूट एंड गिव. तो हमको NOC सबमिट करना पड़ा. बाकी बहुत सारे केसेस में इट वॉज ग्रांटेड, पर एक केस में ऐसे हुआ कि NOC वॉज रिक्वायर्ड. तो इफ़ यू राइट द इंस्टीट्यूट्स एड्रेस, लाइक व्हाट डू दे थिंक कि भाई इंस्टीट्यूट में काम किया है तो वी शुड गिव क्रेडिट टू द इंस्टीट्यूट, दैट इज़ वाई दे कीप द इंस्टीट्यूट्स एड्रेस. पर एक बार ऐसे हुआ था, तो यू शुड बी रेडी कि यू कैन गेट एन NOC फ्रॉम द इंस्टीट्यूट, राइट. सो नेम, एड्रेस, nationality, then comes the preamble. As said earlier, कहाँ गया मेरा वाला, हाँ, title of the invention, name, address, nationality, and then preamble. Preamble में provisional और complete. अब ये आपका invention complete ही हो गया है, it is done. So you will have to write complete. The following specification particularly describes the invention and the manner in which it is to be performed. All these things come on the first page of the form 2. The title, name, address of the applicant and the preamble. ये first page पे आता है, right? Second page से the main application begins. Second page पे वापस title आएगा, उसके बाद आएगा field of the invention. Field of the invention, now your invention is for which field? It is for tablet and capsule system. So what does it suggest? That this invention belongs to the field of oral treatments, oral drugs, and specifies a tablet and capsule system, specifies a formulation for the tablet and capsule system. ऐसा कुछ आएगा. मैंने पूरा तो पढ़ा नहीं है, तो from this I can understand only this, the field of the invention, right? After the field of the invention क्या आएगा? देखो, background. Background में what you have to start, what is tablet and capsule system? पहले भी हो चुका है tablet and capsule system, तो you have to give कि this is already known in the prior, tablet and capsule system already exists, and you have to give some details about it. If there are some patent applications about in this field, mention those. If there are some scholarly articles in some research magazines or publications, you can mention those and give some brief abstracts on that, so that the examiner, the person who is examining, comes to know that all these things have already been happened in the prior art, and your invention is after that, is a step ahead of it, right? तो वो हो गया background. Next will come the object of the invention. What is the aim of your invention? बताइए. आपकी आवाज़ नहीं आ रही है. अब बताइए.
Hello. Ma'am, I am formulating a tablet in capsule system. My drug is for gout. So
Okay.
in gout, in midnight or early morning, gout flares are observed. So sudden gout attacks are observed. So if the person takes the tablet in capsule system at night, the effectiveness will exactly be at the morning time when the serum uric acid level increases.
Sustained release system.
Sustained plus immediate, both release are there.
Okay. So the first object of your invention will be a formulation. The main object of the invention is to provide a formulation and characterization of tablet and capsule system, which helps in the treatment of gout disease and provides immediate and as well as sustained effect. Right? Second object, अब second क्या होता है इससे फायदा? Write that. Third of the another object of my invention is supposed to overcome to stop prevent the pain before it flares up. Suppose this is the second object of your invention. The another object. The third object of my invention is to provide this formulation, which is suppose economical. You can say. This way you have to write what are the important advantages of your invention. Like they are the aims of your invention. आपका aim खाली ये नहीं था कि tablet and capsule system दो. Your aim is also to provide it in an economical fashion. Your aim is also such that the person doesn't have to get up in the middle of the night with the pain. So write all these as objects of your invention. Okay? उसके बाद क्या आता है object के बाद? Summary. Give a brief summary. What is your tablet and capsule system? The tablet formulation contains this and the capsule will contain this. This will be released immediately. This will be sustained release. This drug will be released sustainedly, due to which the flares will be stopped. Write a brief. Understood? Drawings. अब इसमें drawings क्या होंगे? What drawing will you provide? है कुछ? You must be having some validity and data, something ना? Tables वगैरह. हाँ? हाँ, तो give those tables. Right? You can give percentage release, hourly percentage release of the drug. Give some tables like that. And क्या बोलते हैं? Efficacy data. Give that also. Pharmacokinetic data. Give all that. All that data, the tables and graphs will come in the drawings. And you have to add brief description here. Figure 1 gives the, what you say? What to say? Figure 1 क्या देगा? Percentage of drug release per hour. Figure 2 gives the efficacy data. Figure 3 gives, that way you can give in brief. फिर जब complete detailed description आएगा ना, you have to give you have to mention all these figures and give what is total in detail, what is described in this figure. Valid per hour release, तो उसका पूरा description दीजिए. It is released within the first hour, this much drug is released. Within the second hour, this much is released. ऐसे सब आप दे सकते हैं detailed description में. खाली वही नहीं देना है, detailed description में पहले देना है what is your invention. What is your invention and how it works. Then you give, figure 1 gives this data. It shows that in 1 hour this much is released. Give everything in the detailed description. Even अलग अलग formulations बनाए हैं वो भी दीजिए, everything. Right? Then give the advantages. What are the advantages of your invention? देखो हमको 30 pages तक का free मिलता है एक patent application में. So that you can add everything. और बाकी का भी nominal cost पर you can add pages. But give everything of your data in it. Right? You also, हाँ बोलिए. You have to give the details of your experiment.
If I applied the design of experiment, DOE.
Experimental design.
Yes.
Yeah, give that also. Give the experiments you have performed, details of that.
And if there are multiple batches in that, multiple runs, so all we have to show in that?
Don't show all. What are substantial, show those only.
Okay.
सब कुछ देकर क्या फ़ायदा? Thesis में आप सब कुछ देते हो. I know. Thesis इतना लंबा होता है ना, I can't read it. But don't give only what is substantial. Thesis में आपको देना ही पड़ता है because you have to show that day 1 में मैंने इतना काम किया, day 2 में इतना काम किया. That should be shown. ये लोग को नहीं चाहिए. ये आपने 10 साल में किया या एक दिन में किया नहीं चाहिए. They want what is substantial. Give what is important. Then the claims. You have to make the claims accordingly. Formulation and characterization Claim 1 will be formulation and characterization of tablet and capsule system, which in which the tablet contains this drug and the capsule contains this drug, wherein the tablet will be in the sustained release mode, the drug of the tablet will be in sustained release mode, the drug in the capsule will be in immediate release mode, and whatever other important features are there, na, give it in the claim 1. Claim 1 will be the independent claim. किसी भी patent application में. Claim 1 is the independent claim, and in that you have to put all the inventive features of your invention. मुझे इतना सारा नहीं बताना चाहिए, तुम लोग तो मेरा काम बंद कर दोगे. But वो तो है, ठीक है. तो claim 1 में you have to give everything, all inventive features of your invention, and claim 2, 3, 4 will be the dependent claims. They depend on the claim 1. भाई आपने claim 1 में आपने समझो कोई ड्रग का नाम बताइए, कौन सा ड्रग डाला है टैबलेट में?
एलोप्यूरिनॉल. एलोप्यूरिनॉल.
एलोप्यूरिनॉल. तो the second claim will be the formulation and characterization of tablet and capsule system as claimed in claim 1, wherein the allopurinol used is allopurinol with you can give the salts of it, maybe this salt or this salt or this salt is used. Then the third claim will be the second drug which you have used, you can use this salt of it. You have to give the method of making it, the formulation. ऐसे claims, define claims such that they just give your invention and they give everything of your invention. Got it? फिर क्या है? Drawings तो मैंने बताया. What should be included?
Ma'am, how to convert the technical language into legal language?
देखिए ऐसे है ना, लोगों का वहम है कि पेटेंट डॉक्यूमेंट लीगल लैंग्वेज में होता है. मेरा कोई भी एप्लीकेशन मैंने बनाया हुआ देखो, कोई कुछ भी लीगल नहीं है, बिकॉज आई एम नॉट अ लीगल पर्सन, आई एम अ टेक्निकल पर्सन ओनली. आई एम अ प्योर टेक्निकल पर्सन, तो मैं कुछ भी लीगल नहीं डालती हूँ, एंड पेटेंट ऑफिस ग्रांट भी करता है. तो नाउ आई एम कॉन्फिडेंट. स्टार्टिंग में ऐसे लगता था कि मुझे लीगल लैंग्वेज नहीं आती है, आई एम नॉट पुटिंग इट, सो मे बी ग्रांट नहीं होगा, ऐसे डर लगता था स्टार्टिंग के थोड़े एप्लीकेशंस में. पर जब से ग्रांट होना शुरू हुई है, आई एम वेरी हैप्पी, पीपल आर एक्सेप्टिंग इट. So it isn't necessary in any manner that you have to put a hard language. वो इतना ख़राब लैंग्वेज, ख़राब नहीं बोल सकते हैं, बट इतनी डिफ़िकल्ट लैंग्वेज होती है लीगल लैंग्वेज कि आई कॉन्ट अंडरस्टैंड. कितनी सारी पेटेंट एप्लीकेशंस मैं खुद भी नहीं समझ सकती हूँ. तो आई गिव इट इन्वेंटर को कि भाई तुम समझो और मुझे बताओ कि क्या डिफरेंस है तुम्हारे और इसमें. बिकॉज दे आर वेरी लीगल. आई एम नॉट अ लीगल पर्सन. आई हैव डन माई MSc and I have cleared the patent agent examination, and because my concepts are clear, I cleared the exam easily. Concept clear होना चाहिए. It isn't necessary कि legal language लिखते हैं जो लोग, उनकी भी ग्रांट होती है, बस simple language वालों की भी ग्रांट होती है. Invention should be there, right? नहीं तो मैं हूँ. चलो नेक्स्ट. अब किसको करना है? लाइए आपका. देख फॉर्म 2 फर्स्ट पेज होता है ना, जैसे मैंने बोला फर्स्ट पेज पर ये सब होना चाहिए. एंड सेकेंड पेज सर यू हैव टू राइट द टाइटल, फील्ड ऑफ इन्वेंशन. फॉर्मेट ये है, वन बाय वन यू हैव टू ऐड दीज हेडिंग्स, सब हेडिंग्स. अंदर आप अपनी तरह से लिख सकते हो उसकी डिटेल्स. कोई फॉर्मेट नहीं होता अंदर का. क्लेम्स का फॉर्मेट होता है जो मैंने अभी डिस्क्राइब किया, उस तरह से ही क्लेम्स होते हैं, नथिंग एल्स. नाउ दिस इन्वेंशन, व्हाट इज दिस? अ सेंसर बेस्ड डीप लर्निंग मॉडल फॉर अनसीन लोकोमोशन मोड आइडेंटिफिकेशन यूजिंग मल्टीपल सीमेंटिक मैट्रिसेस. ये तो कितना बड़ा है. टाइटल शुड बी बिटवीन 5 and 15 वर्ड्स. बताइए आप क्या टाइटल रखेंगे? 15 वर्ड्स के अंदर चाहिए.
सेंसर बेस कट कर देते हैं. अनसीन लोकोमोशन मोड आइडेंटिफिकेशन यूजिंग मल्टीपल सीमेंटिक मैट्रिसेस, इतना रखे तो या फिर अनसीन लोकोमोशन मोड आइडेंटिफिकेशन कर दे, दैट कुड बी सिंपल।
सेंसर बेस्ड डीप लर्निंग मॉडल निकाल देते हैं।
हाँ, उसको आगे डिटेल में एब्स्ट्रैक्ट में समझा देंगे।
अनसीन लोकोमोशन मोड आइडेंटिफिकेशन यूजिंग, नहीं, यू कैन ऐड मॉडल फॉर अनसीन मॉडल, या कुछ ऐड कीजिए ना, अनसीन लोकोमोशन मोड आइडेंटिफिकेशन यूजिंग मल्टीपल सीमेंटिक मैट्रिसेस। तो व्हाट इज इट लाइक? इट शुड बी सम प्रोडक्ट
using
module for unseen locomotion mode identification, right? It can be the title of your invention. Module for unseen locomotion mode identification using multiple semantic matrices. 15 words के अंदर आ गया, टाइटल आपका फाइनल हो गया। फिर फील्ड ऑफ द इन्वेंशन, नहीं तो हम आगे थे, सॉरी, नेम एड्रेस नेशनलिटी ऑफ द एप्लीकेंट्स वो आप डाल सकते हो। प्रीएम्बल, इफ इट इज अ कंप्लीट प्रोविजनल, तो कंप्लीट का ही ये प्रीएम्बल होता है, राइट? दीज ऑल थिंग्स कम ऑन द फर्स्ट पेज। फॉर्म तो लिखा होता है, फिर उसके बाद ये सब लिखते हैं। यू कैन गेट द फॉर्म स्पेसिमेंट्स ऑन द पेटेंट ऑफिस वेबसाइट, सब फॉर्म्स मिलते हैं।
Okay.
Field of the invention, what will be the field of your invention?
IoT, smart sensing, sensors, ऐसा।
What? IoT?
Smart sensing, sensors, machine learning।
फिर मुझे नहीं समझ में आया उसमें। फील्ड ऑफ द इन्वेंशन से समझ में आना चाहिए ना कौन सी फील्ड का।
IoT, smart sensing, sensors, machine learning या learning
इट
techniques।
शुड बी अ स्टेटमेंट, हमको वर्ड्स नहीं चाहिए। तो IoT, स्मार्ट लर्निंग, हाँ, सेंसर बेस्ड डीप लर्निंग मॉडल, IoT based locomotion mode identification method which uses sensors and multiple semantic matrices for।
मैम एब्स्ट्रैक्ट से वो वहाँ से पिक आउट कर सकते हैं ना, दिस पेपर प्रपोजेज अ सेंसर बेस्ड मॉडल, उसमें 2-3 लाइन में जो लिखा है तो वो
सेंसर बेस्ड,
सेंसर बेस्ड डीप लर्निंग मॉडल टू आइडेंटिफाई यूजिंग
वो
दिस।
सब आ जाएगा फील्ड में। थोड़ा और डिस्क्राइब कर देना।
हाँ, इंट्रोडक्शन का लास्ट पैराग्राफ में भी डिस्क्रिप्शन है, तो वहाँ से उठा सकते हैं।
तो क्या फील्ड से इजीली पता चले कि किस फील्ड का है, राइट? उसके बाद आता है बैकग्राउंड में तो व्हाट इज ऑफ द रिलेटेड फील्ड, इस फील्ड का
ड्रॉबैक्स क्या थे वहाँ से,
व्हाट वर द इन्वेंशंस बिफोर यू एंड व्हाट वर द ड्रॉबैक्स, ये सब बैकग्राउंड में आएगा। यू कैन मेंशन सम पेटेंट एप्लीकेशंस आल्सो, सम रिसर्च जर्नल्स आल्सो, पब्लिकेशंस आल्सो, एनीथिंग यू कैन मेंशन। फिर ऑब्जेक्ट ऑफ द इन्वेंशन, व्हाट वाज द एम ऑफ योर इन्वेंशन?
तो प्रॉब्लम स्टेटमेंट और डिस्क्रिप्शन जो यहाँ पेपर है वहाँ से लिख सकते हैं।
वही तो यू हैव टू मेक स्टेटमेंट्स फॉर दैट। द मेन ऑब्जेक्ट ऑफ
द पेपर वी हैव मेंशन्ड सम प्रॉब्लम स्टेटमेंट, इन दिस पेपर वी आर एड्रेसिंग दिस प्रॉब्लम।
हाँ, तो वो प्रॉब्लम्स है, तो योर इन्वेंशन इज टू ओवरकम दोस प्रॉब्लम्स, राइट? तो वो एक आपको मेन ऑब्जेक्ट ये है, सेकंड ऑब्जेक्ट ये है,
या फिर कंट्रीब्यूशन से उठा सकते हैं कि ये कंट्रीब्यूशन था, तो वो प्रॉब्लम थी ये वाली, तो उसका कंट्रीब्यूशन ये, इस तरीके से।
सॉल्यूशंस, यू हैव टू मेनली गिव व्हाट वाज द एम ऑफ योर, व्हाई यू स्टार्टेड वर्किंग ऑन दिस। तो उसका हम ऑब्जेक्ट में डालेंगे, ऑब्जेक्ट ऑफ द इन्वेंशन में। फिर आएगा समरी, यू कैन गिव अ ब्रीफ
रोड मैप ऑफ द सॉल्यूशन, और
हाँ, हाउ इट वर्क्स, हाउ यू डू इट। ड्राइंग्स, व्हाट ड्राइंग्स
मैम स्क्रॉल करेंगे। ये रहा।
What are these all?
ये तो बेसिक चैलेंज था क्या, फिर नीचे आगे स्टेप्स भी।
हाँ, तो आप तो इतना सारा इन द फॉर्म ऑफ डायग्राम्स यू कैन गिव, राइट? कंपैरेटिव समरी ऑफ एग्जिस्टिंग वर्क, ये भी आप डाल सकते हो। एग्जिस्टिंग वर्क में दिस ऑल वाज एग्जिस्टिंग। वो प्रायर आर्ट में भी आप ये ड्राइंग, प्रायर आर्ट का भी एक ड्राइंग डाल सकते हो, कोई तकलीफ नहीं है। एंड योर इन्वेंशन का वो था, उसके अलावा भी कुछ हो तो ये क्या है? ओवरव्यू ऑफ डीप जीरो मॉडल आपका है ना, IoT बेस्ड है ना, तो ट्राई टू मेक द डिस्क्रिप्शन सच दैट इट डजंट लुक दैट यू हैव पुट ऑल सॉफ्टवेयर हियर। कुछ हार्डवेयर दिखना चाहिए या कुछ सिस्टम टाइप दिखना चाहिए। हार्डवेयर है इसमें,
हाँ नीचे जाके रिजल्ट्स वगैरह
सेंसर्स एंड
हाँ, वो
एवरीथिंग
सब
है,
लिखा है।
तो यू हैव टू क्लेम द सेंसर्स एंड पुट मोर एम्फोसिस ऑन द सेंसर्स, व्हाट आर दोज सेंसर्स एंड द कंट्रोलर विच यू आर यूजिंग, द माइक्रो कंट्रोलर वॉट एवर यू आर यूजिंग, वो सब का डालो. बट हाउ द माइक्रो कंट्रोलर, व्हाट कमांड इट गिव्स एंड ऑल, डोंट पुट ऑल दैट, क्योंकि इंडियन पेटेंट ऑफिस डजंट एक्सेप्ट सॉफ्टवेयर एंड एल्गोरिथम्स. तो वो आप डिस्क्रिप्शन में भी डालोगे ना, तो दे विल स्पेसिफाई कि आपने तो ये पूरा एल्गोरिथम ही है और कुछ भी नहीं है. सो यू हैव टू गिव हार्डवेयर कंपोनेंट्स, व्हाट आर द कंपोनेंट्स ऑफ योर इन्वेंशन, वो दिखना जाना चाहिए, राइट. डिटेल डिस्क्रिप्शन, गिव एवरीथिंग ऑफ योर इन्वेंशन, गिव एग्जांपल्स like you showed in the drawings, how it helps your invention for the thing. You can show that, give examples. Advantages तो है, you can show them and claims should be very specific. कोई भी software part मत डालो, give the components, what are the main components of your invention, this hardware, this is connect and how it works. बट डोंट वो मेथड स्टेप्स वगैरह मत डालना कि भाई इसमें द माइक्रो कंट्रोलर गिव्स दिस कमांड, तो वो माइक्रो कंट्रोलर कमांड दे रहा है तो दैट इज सॉफ्टवेयर, दैट इज एन एल्गोरिथम, वो फिर एक्सेप्ट नहीं होगा, राइट. हो जाएगा.
यस ओके मैम, थैंक यू.
अब क्या करना है? क्वेश्चंस, किसी और को कुछ पूछना है, एनीथिंग यू कैन आस्क अबाउट पेटेंट ड्राफ्टिंग. If your paper has been published, your paper has already been published in a reputed means acceptable journal like a, so you can file a patent within 1 year. After 1 year prior art में आ जाता है तो it won't be considered. 1 year के अंदर you should file a patent. Otherwise the main approach should be always for the researcher, first apply a patent. If you think it is patentable, then go for the paper publication. प्रोविजनल डाल दो, पर डालो पेटेंट एप्लीकेशन प्रोविजनल कर दो, वो तो अपने आप भी कर सकते हो, बहुत डिफ़िकल्ट नहीं है. देखो मैंने इतनी आई थिंक काफ़ी कुछ सिखा दिया है, तो यू कैन एटलीस्ट फाइल अ प्रोविजनल एप्लीकेशन, बाद में आप पेपर पब्लिश करो, नहीं तो इट विल बी वेस्टेड. बिकॉज आफ्टर द पेपर पब्लिकेशन कोई भी कॉपी कर सकता है, एनी वन कैन वर्क मोर इन दैट फील्ड and your invention will go waste. That is why. Questions, anybody? Nothing? या तो समझ में नहीं आया या सो रहे थे. पेटेंट का ऐसे ही है, मैंने भी ज्वाइन किया था, मुझे ऐसे ही लगता था कितना ऐसे यानी बोरिंग वाला है, पर ठीक है अभी इंटरेस्टिंग लगता है. बिकॉज आई गो इन द टेक्निकल एस्पेक्ट्स ना, सब कुछ रोज़ मुझे नया इन्वेंशन मिलता है. बिकॉज आई गो फॉर ऑल द फील्ड्स. मुझे कंप्यूटर रिलेटेड ज़्यादा पता नहीं है तो भी मैं उसमें समझना का ट्राई करती हूँ कि भाई दिस इन्वेंशन तो मुझे पता चलना चाहिए. फार्मा तो मेरा लाइकिंग है, तो आई गो डीप इन टू इट. Anything? Okay. Thank you for being such a nice audience. Really appreciative.
Thank you, ma'am. Thank you, participants. Now, I request Professor Manish Gupta, sir, to thank Ms. Kavita Shah with the bouquet and gift. Thank you, sir. Thank you, ma'am. We have concluded all the talks and hands-on session for the day. I thank you all for participation. I request Professor Manish Gupta for his vote of thanks.
Thank you, Kathy. And I think it was a learning experience for all of us. We have enjoyed. It was a long day, but I think each session was very important, starting from grassroots innovation to thinking that four-dimensional strategy of Professor Anil Gupta. After that, two talks about the Dr. Yashwant, and before that, even talk about Dr. Narotam Sahu about the Gujarat government initiatives, especially Goose Cost. And then we also have Dr. Andrew talk, right, about the WIPO. I think, and he's very much interested in collaborating with India actually, so he was, so we have discussed about many things. So I think that's really important. And another thing is that, basically, and especially this session by Kavita Madam,